2023 CR 11510A, B, and C. Present in the courtroom, attorneys for both the state and the defense, as well as each of the defendants. We have a juror that's been late, half an hour late at this point, so we're going to go ahead and proceed with the hearing outside of their presence. The jury is not in the courtroom. Let's take up a matter that the state filed a motion in limine regarding expert testimony. State, what do you have on this?
Your Honor, we simply are asking the defense to approach before they intend to offer any evidence from an expert or otherwise about the state of mind of either of the three defendants. In this case, there's been a lot of suggestion from their questioning or something to call expert witnesses to talk about what a reasonable person would believe under the circumstances. It's not proper under the law. It's pretty clear that the only times that a person could put on evidence such that is or state of mind evidence is with an insanity defense or with a defense of a justification on a domestic violence victim situation under 3836. So we just want to be sure that there are no references to that in opening statement or any of that evidence is elicited through a expert or witness that the defense intends to call unless they approach the bench and we have a hearing outside the presence to see if that's what's going to happen.
Judge, in response to that, I would agree that the experts can't say what the particular defendants were thinking at the time, but I believe that they are able to opine upon what a reasonably trained officer in a similar situation would reasonably believe and whether reasonable belief would be consistent with certain facts. So I don't think we should be precluded from asking questions in that format.
And considering that this is not a federal trial, this is a state trial guided by state laws, the element for the jury to consider is the ordinary and prudent person standard. It has nothing to do with evidence about what a reasonable police officer would do based on what a purported expert would have to say about that. And it's already been decided by the court that the state can't do that. So what's good for the goose is good for the gander. The defense can't do it either.
Because I don't think it's been decided by the court that the state can't do that. I think that they didn't have anybody willing to say that. But as far as I mean, Mr. Cifuentes is right. There's an objective, but there's also a subjective standard that goes under that, because you have to, then the court's going to instruct the jury that they have to put themselves into the position of the officer, as viewed from their standpoint, as viewed from, and you know, by necessity, they have to view it from the standpoint of men acting as police officers, doing what they were doing at the time. So it's that subjective part of it that our experts, who are all also police officers, former police officers, and have been trained and trained, all of those things they can talk about how training, how perceptions, how those perceptions all work together in order to be able to form a reasonable belief for an officer. And as Mr. Cifuentes said, we're not offering any testimony as to like what these individuals were thinking at the time. And that's what the state is talking about in their motion, which I agree with that. Like we don't, as far as their motion is covering what these individual officers are thinking at the time, there's not an expert that can testify to that. But they can testify as to what somebody in that situation would be experiencing, would be thinking, how they would be reacting, and whether or not that was reasonable. And that is what we're going to offer the testimony on. So rather than have to approach, we just like the court to make a ruling that would be appropriate, so we don't have to keep coming up every time we want to ask those questions.
And Your Honor, we've asked to do that. We've asked to do that. And then if he's saying that they would be allowed to do that, in the same way we should be able to do that. But the court has, by its earlier rulings, said we can't mention policies and training and how they affect the subjective reasons of an officer or these officers at the scene. So I don't understand why they're arguing that they can do it when we cannot.
Well,
I don't understand.
Yes, Your Honor, but that's not what the court restricted. We did ask to restrict on like policies, SAPD policies. We're not going to ask our experts those things. We talked about tactics, and I believe the court restricted what they were trying to give as like tactical officers to talk about those tactics. We're not going to be asking about tactics. We're going to be asking about when somebody is at a place and a woman is coming at them with a hammer in this situation, what does training, because training is important, and they have asked about training. Training is important because you were trained to, for instance, you were trained to meet deadly force with deadly force. You were trained to draw a firearm when confronted with a weapon. And we've been talking about that the entire trial. And so things like that as part of their training is definitely relevant. And these experts who train police officers to do these things would have the requisite expertise to be able to talk about those things.
Then we won't rest. If we're going to be able to do that as well, Your Honor, if you're going to lift that prohibition on us being able to talk about what a reasonable police officer would do based on a person's years of training and expertise and experience in the field, then we wish to put on more witnesses, because we have been prohibited from doing that. Your order explicitly said we cannot talk about training, and we can't talk about policies. And those are exactly the kinds of things that would inform these experts' opinions on what a ordinary and prudent police officer would be doing from their standpoint.
I think the distinction, Judge, is use of force, reasonable use of force, and whether it's imminent versus policies. And it came out, even though it was asked, it still came out that policy is not the penal code. So I'm not sure what the confusion on the distinction is. I mean, you had Detective Soto arguing that I just think they could have done things differently. Well, we can have an expert to say, no, they shouldn't have done things differently under those circumstances that they were dealing with. So that's a reasonable use of force. That's something the jury needs to hear evidence on. Now, the individual SAPD policy was what you ruled on. Whether the policy general manual 501 or 502 says this, well, that's irrelevant when it comes to the penal code. But when it comes to reasonable use of force, I don't believe that's what the court's instruction was. And as a matter of fact, their detective made a comment on it, so we should be able to rebut that.
Let me ask the state, so what did you expect, or what would you expect your witnesses to testify to specifically?
We would expect them to testify from their years of training and experience and their training of police officers in the field in handling emergency situations, barricaded situations of individuals, that they're trained to respond in a certain way, that their mindset is considered as far as preserving life, protecting life in these situations, and exploring other alternatives before jumping into a situation where an officer might get hurt or a victim might get hurt. The person can, the other people we have other experts who can talk about, they trained these officers specifically on how to handle these kinds of situations. And if they didn't handle them the way that they had been trained in less than a year before, it suggests that an officer is acting, if they're acting against their training and against their policy, they're acting unreasonably in their response.
Well, that was, I'm sorry, David, you're not finished, go ahead.
And all the things that they purported to talk about as far as how officers respond and are taught to use force in certain situations and to de-escalate in other situations are the same things that this expert can talk about without talking about what these particular officers believe.
I think the slippery slope is what he mentioned is the policy, Judge, versus reasonable force, and whether it was excessive or not, or that circumstance. I mean, the SAPD policies are relevant when it comes to reasonableness under the penal code. So if that's the distinction and that's the confusion, so I don't think that our hands should be tied to show that under these circumstances that this behavior was reasonable. And again, forget policy. We're not going to mention SAPD policy because we don't care about it at this point. But when we're talking about the penal code and what this jury has to deliberate on, I believe we should have the opportunity to offer evidence to show that they were reasonable.
And Your Honor, counsel realizes it's the only argument he can make, and he's got to be an advocate, but it totally misses the point of what Chapter 9 says. Their witness, Detective Soto, said the only reason the officers were not reasonable is they failed to choose an alternative aside from the one they chose, and their plan was wrong. But he did not negate that Melissa Perez's threat was immediate. He did not negate that her threat to use the hammer could cause serious bodily injury or death. He did not negate that the defendants could reasonably believe that force was immediately necessary to stop Melissa Perez's unlawful use of force. So, again, we argued previously that bad tactics did not cause her, Melissa Perez, to engage in the unlawful conduct. And under Texas Penal Code 6.04, what they're attempting to do is to suggest that they provoked the difficulty by their bad choices. And you've already ruled on this, and federal courts have already said there's no such thing as officer-created danger. In essence, officer-created danger embraces concepts in the Texas Penal Code, which is, number one, that officer-created danger does not trigger the causation necessary in 6.04, that their bad tactics was sufficient in itself to cause her to engage in bad behavior, illegal behavior, violent behavior, behavior that threatened their lives, and that it threatened their lives in a way that required an immediate response. Their suggestion that bad tactics caused those things is totally untrue, can't be proven, and not even their witnesses testified that it caused her to engage in violent behavior. In addition, 38.03b says that you don't have the right to resist arrest, whether it's lawful or unlawful. So they're trying to get through the back door issues that this court has already ruled upon and precluded them from introducing. So their suggestion that what we're trying to do is improper is misleading, because they simply can't say that bad tactics is the cause of the behavior, or that they provoked the difficulty, or that somehow or another their bad tactics gave her a right to resist an arrest. So we would ask that their motion be denied to the extent that that's what they're suggesting, that they want to get into bad tactics.
All right, so let me do this. So as it relates to the state's motion in limine regarding expert testimony, I'll grant the state's motion. As it relates to the defense experts and testifying, what I'll do is I will recognize and I'll allow that testimony, and then subsequent to that, state, if you want to call any witnesses to rebut, then you could do that.
Okay, let me just see if I'm clear, right?
Yes.
Motion limited is granted, they can't talk about an opening statement. Any expert that they call that purport to do that will have a hearing outside the presence of the jury.
Yes.
To see if they're within the bounds.
Yes.
Right? And if that's the case, what they testify to, we are permitted in rebuttal to talk about those things, whether it be training or policy or whatever it is necessary to rebut what they say.
Correct.
Okay, understood.
All right. Anything else?
There you go.
With that understanding, are they going to arrest or not?
We are. We will rest on that basis.
Okay.
And if we can take a short recess, I'd be ready to argue immediately afterwards on the instructed verdict.
Okay.
Maybe take a break.
Yes. Let's take a short break.
And Judge, I think Mr. Limine said, well, if he granted it, then he would call witnesses or whatever. I guess the idea is we can argue it and the court can reserve its decision,
Yes.
just so we can save time.
The jury project position here no later than 10:15.
All right. So the juror says that they'll be here in about 25 minutes, so we still have time.
May be seated.
Welcome back, members of the jury. Hope you had a pleasant evening. Hope you had a good morning. We're going to proceed today. Going to give you a lunch break. And I know there was a question with one or more of you about leaving at a certain time today, so we'll leave between 4 and 4:30 at the latest. We'll try to aim closer to 4, depending on where we're at. All right, where we last left off, State, we were in your case in chief. You may proceed.
Stay with rest on this case in chief, Your Honor.
All right, members of the jury, what that means is that we're going to have you go back into the jury room. We're going to take up a matter outside your presence. I'll bring you back when we're ready.
All right for the jury. May be seated.
All right. Defense?
Your Honor, I would like to proceed first on a motion for instructed verdict. I must confess to the court that last night I had 4 editors contributing a written draft. I'd like to be able to read it into the record because unfortunately I was unable to blend it into one document. If I may read it into the record, I'd like to proceed. And if I may be seated while doing so.
Yes.
In a case style 2023 CR 11510A, B and C, State of Texas versus Alfred, Flores, Eleazar Alejandro, and Nathaniel Villalobos in the District Court 379 Judicial District, Bexar County, Texas. Following motion for instructed verdict is made by the undersigned Ben Cifuentes to the Honorable Court, to the Honorable Judge of said court. Now comes Alfred Flores, Eleazar Alejandro, and Nathaniel Villalobos, defendants in the above style and numbered cause, and moves this court to order an instructed verdict of not guilty and for good cause shows the following. The state has failed to prove the essential elements of the offense alleged against the defendants, including disproving the defense of justification. At this time, I would request the court to, for the limited purpose of this hearing, to take judicial notice of document 71, which we previously have asked the court to take judicial notice of, and that is case number 5:23 CV 00847-FB. Judge Bemperod's report and recommendations of a United States Magistrate Judge. We ask, it's a 21-page document which we previously provided to the court. We ask that the court take judicial notice of this for this purpose of this hearing. We believe it's relevant and admissible for the judge determination in this case outside the presence of the jury because, as we will set forth in detail, the document 71 details why the actions of the defendant was reasonable under the circumstances. The actions that are alleged as the basis of the indictment, that the threat by Melissa Perez was the threat of serious bodily injury or death with a deadly weapon and with a hammer, that the officers believed that it was immediately necessary to defend themselves against the unlawful use of force was necessary and reasonable, and they had no duty to retreat, and that there were exigent circumstances to make the entry. All of these findings negate any claim by the state that the officer's conduct was not justified. Moreover, the state produced no evidence to refute the findings of the magistrate judge. Since they produced no evidence to refute the findings of the magistrate judge, there's no evidence to disprove the justification defense that the defendants have advanced. I will return to that document, but I will continue with my assertions that the defendants were peace officers in the lawful discharge of their duties as San Antonio police officers attempting to arrest Melissa Perez on June 23rd, 2023, when Melissa Perez resisted a lawful arrest after she committed the following felony offenses of criminal mischief of a fire alarm, and 3 aggravated assaults against a peace officer. When the defendants began implementing their lawful arrest of Melissa Perez at approximately 02:02:04 a.m. on June 23rd, 2023, Melissa Perez ran to retrieve a hammer and ran towards the patio window of her apartment living room while raising and swinging the hammer tomahawk style. The undisputed video evidence from 4 or more body cameras confirmed this deadly attack, and witnesses testified this charge and assault could be reasonably perceived as an attack with a deadly weapon. I wish to point out that the magistrate judge's report considered the pleadings in the civil case, and the magistrate judge wrote, however, the court may also consider documents attached to a defendant's motion to dismiss when they are referenced in the complaint and are central to the plaintiff's complaint. And then the magistrate judge went on to explain in this footnote number 2, in their response to the officer-defendant motions, plaintiffs also confirmed they do not object to the courts considering the body-worn camera footage when evaluating the merits of the motion, and aver that the motion should be cited on the record at hand, including the body-worn camera footage. When this court reads the document 70, this court will realize that Magistrate Judge Bimperod reviewed the same body-worn camera videos which were introduced in this case, including those of the defendants. Thus, when we assert that the undisputed video evidence from 4 or more body cameras confirmed the deadly attack, that was also confirmed by Magistrate Judge Bimperod. Continuing further, the crime scene detectives who measured the width of the patio and estimated the placement and size of a window screen that was knocked down to the patio floor by Melissa Perez's hammer swing at 1:40:50, and this was on Officer Ramos and Officer Salinas' body-worn camera, and at 02:02:07, which was on various body-worn cameras and stills, and in particular Edwin Rivera, agreed that one corner of the screen was more than 1 foot from the outer patio rail. Detective Soto agreed that the specific corner identified as noted previously by the CSI and in this motion was where Alfred Flores' feet were located when the hammer struck the patio window. All witnesses either agreed or did not dispute that when Melissa Perez struck the patio window at 02:02:07, the hammer was less than 5 feet away from the back of Alfred Flores' head. In the undisputed testimony by various detectives and in the videos, all the witnesses testified that at the moment that Alfred Flores was negotiating the patio rail, mounting the patio rail as if he was mounting a horse and turning counterclockwise, that he lacked the ability to see Melissa Perez's unlawful deadly attack with the hammer. In essence, he was defenseless at that moment in time. Being defenseless, he lacked the ability to perceive the danger and dodge or avoid being hit with the hammer. All witnesses either agreed or did not refute that the hammer swing was in a trajectory in line with the back of Alfred Flores' head. This was confirmed by at least 3 or more body-worn cameras in the trajectory of glass that was subjected toward the back of Alfred Flores' head as a result of Melissa Perez's hammer blow was in line with the swing, contact, and the direction to the back of Alfred Flores' head. Eleazar Alejandro gave a statement to Ronald Soto explaining he believed that Melissa Perez was throwing the hammer towards Alfred Flores' head, and all witnesses confirmed that at this moment in time, Alfred Flores was defenseless. This belief by Eleazar Alejandro, as set forth in the statement, was not refuted by any witness. Eleazar fired 5 shots in less than 2 seconds to stop Melissa Perez's deadly assault. There's no evidence that any of these 5 shots hit Melissa Perez. Now, Afterwards, Melissa Perez ran back to her living room couch between 02:02:07 and 02:02:09. She then got up from the couch, went to the open hallway between her kitchen and living room, and stood facing the patio door to the right field of view from the body camera. At 02:02:10, she was standing in the hallway with the hammer still in her hand. She looked directly at Alfred Flores for a second, then began charging rapidly, aggressively towards the patio door, which was a French-style window door where both Nathaniel Villalobos and Alfred Flores stood. A reasonable officer, Eleazar Alejandro's situation at 2:02:12 would have believed that after the first charge, the first volley of shots, Melissa Perez would have surrendered by throwing down her hammer, giving up her deadly weapon, and showing a willingness to submit to an arrest. Instead, having been fired upon, she again began a second deadly attack, showing a determination to kill or to be killed resisting her arrest. Her intent to resist arrest is confirmed by the fact that she stated on body camera several times, "Shoot me," and that was during the first time she swung the hammer twice at Jonathan Salinas. Then several times she informed officers that she was not going to go to jail again, that she's already been to jail 3 times and she's not going to do another 45 days. Additionally, in the second attack at 1:55 against Nathaniel Villalobos, afterwards she stated to Officer Villalobos, I believe she used the F word, and then said, "Fight me." It's noteworthy that during both of these assaults against Jonathan Salinas and Nathaniel Villalobos, approximately 11 minutes apart, several officers drew down and pointed their weapons at Melissa Perez for a lengthy period of time, knowing that the officers were threatening deadly force against her based upon her unlawful use of a deadly weapon, namely a hammer. Continuing back to 02:02:07 and the second charge, Melissa Perez charged towards the patio door the second time, and only when she was nearly against the wall in line with the patio window and patio door did Alfred Flores fire at 02:02:13 when Melissa Perez was upon the door, had the ability to exit and attack the officers. As noted in Judge Bimperod's opinion, it would be unreasonable for the officers to have retreated at that moment in time, because even Judge Bimperod noted from the body-worn cameras that both Sergeant Flores and Nathaniel Villalobos had difficulty negotiating hopping over the patio railing, and Judge Bimperod determined that retreating would not have been practical, even though the officers did not have the duty to retreat, and that had they retreated, Melissa Perez could have opened the door and attacked them, and they would have been vulnerable the way Alfred Flores was vulnerable by being hit in the back of the head. After Alfred Flores fired 3 shots between 02:02:13 and 02:02:15, Nathaniel Villalobos fired 3 shots into the wall where he reasonably believed Melissa Perez to be standing. Nathaniel Villalobos reasonably believed that while Melissa Perez was standing in this 2-foot wide wall, that she could have either have moved, and from the perspective of the officer, she could have either moved to the left and thrown the hammer through the open window at Officer Eleazar and Travis Thompson and others nearby, or have opened the door or swung the hammer through the windows and struck either Nathaniel Villalobos or Alfred Flores. After Nathaniel Villalobos fired, officers yelled out that Melissa Perez was down. Noteworthy, all the officers ceased firing when the danger was no longer present. Nathaniel Villalobos belied any intention to cause the death of Melissa Perez when he kicked in the door to make entry to be able to render first aid. He found Melissa Perez inside, and the video camera shows that she was still holding the hammer in her hand, and that he immediately grabbed the hammer and threw it to the side against the wall to the right of the patio door, and then immediately began administering first aid in an attempt to prevent Melissa Perez's demise. Officer Eleazar Alejandro later jumped the railing, entered the apartment, and attempted to assist in life-saving efforts before Eleazar Alejandro was ordered to leave the apartment. Detective Soto admitted in testimony that this conduct shows and belies any intent to cause the death of Melissa Perez, and these actions show that they were trying to save her life. And the course of conduct in this 8 seconds of time was immediately necessary to effect a lawful arrest and to prevent Melissa Perez's unlawful use of deadly force against Sergeant Alfred Flores and Nathaniel Villalobos. The state has suggested that the defendants acted as parties to commit the offense. However, as this court knows, mere presence alone is insufficient to make one a party to an offense. The state must prove that the parties acted with the intent to commit the offense. There's no evidence there was a prior agreement between the parties to commit the offense, and there's no evidence that one or more of the defendants encouraged, aided, or abetted the others because there was simply no time to take action. The fact is that each individual defendant responded independently because of the threat of unlawful deadly force that they saw Melissa Perez engage in, and they acted independently to protect themselves and third persons and to effect an arrest. Thus, there can be no law parties in this case. And as stated before, Detective Soto testified that he did not believe that defendants had the intent to commit murder, else they would not have attempted the life-saving measures. The state sought through various theories as to why it believed defendants committed murder, but in the course of nearly a 3-week trial, this court has seen how those theories have changed as the court refused to permit unsound legal theories to be unveiled. Such legal theories were inconsistent with the state's conduct in violation of Texas Code of Criminal Procedure, Article 20A.256, and also the Code of Respect 3.09 of the Texas Code of Professional Responsibility. Specifically, the state sought to suggest that Officer J. Salinas was trespassing or committing a burglary when at 1:40:50 or so, he attempted to enter Unit 3102, and that he was told by the state that had Melissa clocked him with a hammer and hit him in the head, and had he died, she would not have been charged with any crime because he was unlawfully entering the residence. When that theory was not allowed, the state then changed its strategy and testimony. What's noteworthy is that the state refused to grant several witnesses immunity, witnesses whom they did not call. They did not grant immunity to Travis Thompson, Vince Gomez, or Maria Salinas, and they did not call those witnesses. Noteworthy, each of those witnesses gave written statements which could not be introduced because they were hearsay, and thus they thwarted the defendant's constitutional right of confrontation and compulsory process. Now, then the state again shifted its theory that the defendants needed a warrant. This theory was again precluded by the court, and also Judge Mimparab, his opinion clearly delineates that there were exigent circumstances to enter. The exigent circumstances to enter were that Eleazar Alejandro had the need to enter, or the officers had the need to enter because the homeless individual, invalid, Santos Villarosa, could not be left alone with a woman who was psychotic, crazy, aggressive, a drug addict, and so forth, and it was necessary to protect them. Even the fire lieutenant and Officer Ramos agreed that they would not leave a loved one alone in Santos Villarosa's situation with Melissa Perez. After the court refused to permit the state to advance the theory that the officers needed a warrant, the state then shifted to that the officers provoked the difficulty by seeking to arrest Melissa Perez. The court once again refused to permit the state to present this theory. This theory is unsound, as we have pointed out in the trial. This theory is insufficient to trigger application of Texas Penal Code Section 6.04. That is, that the officer's misconduct has to be sufficient to cause a particular result. And what, in essence, the state was arguing was that the defense caused Melissa Perez to engage in the deadly attack. Clearly, their conduct was insufficient to cause her to engage in the deadly attack, and federal courts have ruled numerous times that there's no such thing as officer-created danger. After all of the state's theories were precluded, the state was left only with the opinion of a botched investigation from Detective Soto, who conducted an incomplete investigation. He was inexperienced and was not truthful in his arrest warrant. He was not truthful and in his prosecution guide. He was not truthful in his testimony. For example, Detective Soto in his affidavit for arrest falsely stated he reviewed all the available digital evidence. This was not true because he admitted that 15 officers uploaded their body-worn cameras by 5 a.m. on June 23, 2023, and a review of the audit trails in Defense Exhibit 102 shows that, in fact, all 15 officers' body-worn cameras were uploaded on or before 5 a.m. on June 23, 2023. If all the cameras, the footage had been uploaded, then the footage should have been available for Detective Soto's review. When Detective Soto was confronted with his user audit trail showed that he only reviewed Eleazar's body-worn camera for a few minutes, he changed his testimony. The custodian of records for the audit trails testified that if one does not document their review of activity, the failure to document means that the activity did not happen. Detective Soto had difficulty accepting this until he was met with receipts proving this is so. The first set of receipts proving that the failure to document means that it didn't happen was his own prosecution guide. His own prosecution guide showed that he only detailed 4 body cameras in detail, and he had to admit that his ability to detail those 4 body cameras took approximately 4 months. He would not admit that he had most of his time to do that, but eventually admitted that he probably had about 180 hours or more to review those body cameras. His audit trails also proved that he did not review in detail those body-worn cameras. When confronted with this, he suggested that he reviewed them with his team of detectives, and I believe that ultimately he said he had a team of 8 detectives. If that's incorrect, I apologize to the court. But he admitted that he had help from other, he suggested he had help from other detectives. In fact, none of those detectives who assisted came forward to corroborate his version of events. In fact, the one witness that testified, the detective that testified was Detective Deanna Plott, and she admitted that she did not consult much with Detective Soto. In fact, that she took a limited statement based upon her interview with only the witness and did not discuss details with Detective Soto as he would suggest. Then, when he was confronted with another lack of receipts, he decided that he was going to testify that he did take handwritten notes. When confronted with the fact that we, the defense, wanted copies of those notes, he stated that he provided them to the state. In the course of the trial, we asked that those notes be turned over to the defense. The state seemed to be eager to turn over handwritten notes. When we reviewed those handwritten notes with Detective Soto, he had to admit that none of those notes related to, the 7 pages of notes related to body-worn cameras. When he admitted that none of the notes that were turned over by the prosecution related to body-worn cameras, he admitted that he did not review all of the body-worn cameras from beginning to end. And he admitted that he did not look in detail at 10 of the body-worn cameras. Thus, essentially what he has done is admit that he was untruthful, that he conducted a sloppy and incomplete investigation. So he only confessed to the truth after his false testimony became manifest. Given that his false testimony was revealed through cross-examination, he should have no credibility whatsoever. Additionally, as part of the receipts showing that he did not have the ability to look at all the body cameras, he had to admit that he interviewed the Melissa Perez family sometime between 12:10 and 1 o'clock p.m. And he did not start drafting the search warrant until after that interview. With respect to the Melissa Perez interview, he admitted at least 10 or 15 different facts that related to Melissa Perez's state of mind of being aggressive, and that he did not include any of that information in the warrant, did not obtain any of that information prior to the arrest warrants. When he was questioned about his affidavit, he admitted at least 10 or 15 critical facts that he omitted from his arrest warrant affidavit that would go to the calculus involved in the totality of circumstances in weighing whether the conduct by the defendants was justified. By admitting his omissions, he explicitly admitted that either he failed to watch 10 videos to obtain the arrest warrant, or that his omissions were intentional and material. Either conclusion would be fatal to his credibility as a witness, and any claim of unreasonableness coming from him would lack any credibility whatsoever, and would necessarily mean that the state failed to meet its burden of negating justification beyond a reasonable doubt. Now, in essence, the state's case rests on the shoulders of one man, Detective Soto, and as we have pointed out, that proof has evaporated. The law is clear and unforgiving. Once justification is raised, the state must disprove beyond every reasonable doubt the justification. And that case on point is Saxon versus State, 804 Southwest 2nd, 910 at 914 was the Texas Supreme opinion dated 1991. This is not a burden the state can waive with speculation, assumptions, or detectives' personal opinions about what officers should have done. The question is singular and precise. At the moment deadly force was used, was Officer Alejandro's belief, and also those of his fellow co-defendants, was it immediately necessary to protect himself and another person from Melissa Perez's use or attempted use of unlawful deadly force? And this is set forth in Texas Penal Code Section 932A. In response to that question, the state has offered absolutely zero evidence that the defendant's conduct was unjustified. The legal standard is not some evidence, but legally sufficient evidence. The court knows the standard. It is not whether some evidence exists, it is whether it's legally sufficient that would allow a rational juror to find beyond every reasonable doubt that Officer Alejandro and his co-defendants were not justified under Penal Code Section 932. A mere scintilla of evidence is insufficient to avoid a directed verdict. The evidence must be legally sufficient to support a rational finding against the justification defense. The threshold question is whether, viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the offense and rejected the justification defense beyond a reasonable doubt. Again, we cite Saxton 804 Southwest 2nd at 914. Clearly, the answer to this question is no. As previously pointed out, Detective Soto admitted that he did not watch all of the videos. He said, "I did not watch all of them, no sir. I just didn't watch all of them start to finish, that's it." And the affidavit for arrest warrant says, "After review of available digital evidence." Well, that's not true. That shows that he intentionally falsified his affidavit. What's noteworthy is that he suggested that he did this on independent impulse, on his own initiative, that he rushed the warrant for no reason, that his command staff did not put any pressure on him. Yet, at the same time, he is a brand new investigator in the office of the officer-involved shooting team, and none of his team members assisted him in any way. None of his team members said, "Hey, slow down," not even his sergeant, not his lieutenant, not his captain. Additionally, Detective Soto admitted that he had no evidence that he shot Melissa Perez. Yet he charged 3 officers with murder when he knew that it was not possible for 3 officers to have fired and hit Melissa Perez. And in fact, he agreed when the medical examiner confirmed that it's unknown whether 1 or 2 gunshots came from 1 or 2 different shooters. Thus, Officer Soto and the medical examiner's office and those who testified from the medical examiner's forensic crime lab could not establish beyond a reasonable doubt the cause of Melissa Perez's death. And additionally, when cross-examined, Soto would constantly say, "It was my opinion, it was my assumption." He finally had to admit that his assumption is not a fact, and he had admitted that his opinion doesn't matter when it comes to the critical issue. The defense asked him, "Detective Soto's opinion, right, doesn't trump the law. Do you agree with that?" And he said yes. The defense asked, "You would agree with me that nothing in Chapter 9 says that if you don't make the perfect tactical choice, you lose your justification?" The defense asked, "Have you read Chapter 9 of the Texas Penal Code?" Soto said, "Yes, I have before, yes, sir." But Soto's entire theory rests on his opinion that the officer should have done something different. His opinion does not address whether the threat was real or apparent or reasonable at the time the officers fired between 2:02:07 and 2:02:15. He only used his opinion that there was some driving force that required officers to enter. It's clear that when he was describing certain things such as driving force, barricade, retreat, tactical retreat, that none of those terms were used in his prosecution guide. What this court can reasonably deduce is that some political pressure came down and caused him to used such terminology when he did not use that in either his affidavit or his arrest report. Additionally, Texas Penal Code Section 9.32 contains no perfect tactics requirement. There's no Monday morning quarterbacking exception. And the only provision in Chapter 932 that applies was whether deadly force was justified because the officer acted as a reasonable officer would have done under the circumstances of the defendant. And even when Detective Soto was offering his opinion about what the driving force was, he testified, I just don't understand why, what the driving force was to get in that apartment right then.
I'm sorry, repeat that?
To get in that apartment right then. The defense said, but Detective Soto's opinion, right, doesn't trump the law. You agree with me? He said, yes. The defense asked, officers have every right, just like everybody else, to defend themselves. You understand? Soto said, yes, sir, I agree. At this time, Your Honor, I would ask that the court permit Mr. Del Prado at the appropriate time to complete the argument, and if he wishes to do so at this time or wait until the other attorneys address the court, I will defer to Mr. Del Prado.
Your Honor, I think Ben's pretty well covered it. Just a couple of things that I want to go over and touch on. I think it's abundantly clear to the court, hopefully it's abundantly clear to the court, as the gatekeeper in determining whether you allow this case to get to a jury. We all watch these videos, and I think it's fair to say that this jury has probably watched these videos certainly more than the state's lead detective, who was at a loss for the names of the personnel or when and where things occurred. When the videos are slowed down, it's apparent, and not even getting into Ms. Perez's first two deadly attacks on first Officer Salinas and then Officer Villalobos, but when Sergeant Flores and Villalobos were on the patio, her first deadly charge for that incident, and it slowed down, everyone, even the detective agreed, yes, the officers were met with deadly force and they are entitled to use deadly force at that moment, because every single case, every single law says that is the moment of truth. At that moment, was it immediately necessary to meet? Did they have a reasonable belief as to that? And not even this detective could dispute that. So when it slowed down, that was clear. And then Mr. Nesbitt put on a brilliant demonstration showing the court and this detective, who once again was shown to either have a faulty memory or just to be making things up because he hadn't watched these videos closely enough. If he would have slowed them down, or if at the grand jury presentation it had been slowed down for the grand jurors. We're here like some 860 days after this incident, Judge, and apparently no one from the state or the San Antonio Police Department ever slowed these videos down to see, because even the detective agreed, yes, the charge at the door, the sergeant waited until the last possible moment, and he acted in protection of himself and Officer Villalobos, which they're entitled to do under the law. To protect themselves from deadly force, they're entitled to meet deadly force. Not just police officers, but any citizen of the state of Texas. So I think that was clear. Just watching the videos, we can say these men acted legally, they acted appropriately, they acted reasonably. And then, as far as the charge of murder goes, and the jury saw and the court saw, these officers acted immediately to render medical aid to save this woman's life. And their own witness said yes. He said they didn't intend to kill her. They've undercut their own charge for murder, and their other theory of murder there's been absolutely zero evidence of. So their only witness says, yes, these men did not intend to kill her. That undercuts their entire prosecution. And I know Ben has covered the ineptitude of this detective and just the arrogance of an unprecedented murder prosecution. We have never in this county had on-duty San Antonio police officers charged with murder. Now we have 3. So who do they decide to put on the case? Somebody with absolutely no experience in an officer-involved shooting. Somebody who says, I have no experience in the use of deadly force. Judge, with all due respect, that's all this case comes down to, is the use of deadly force. And he even said, you know what, at that academy, we have plenty of people who are experts in the use of deadly force. He didn't even pick up the phone to call one. The state decided to put up in a case that is singularly about the use of deadly force, they decided to put on the stand a detective who knows nothing about the use of deadly force. And their expert, Mr. Joyner, is sitting out there in the seats over there. They chose not to put him on. There has been no testimony as far as the use of deadly force, except he had to agree once he was shown the videos, slowed down, yeah, it was justified, it was legitimate. So the murder case has been undercut, and the last thing, Judge, I want to say is Judge Bemperard and Judge Beery. Judge Bemperard watched these videos, just like this jury did, just like the court did, and under a lesser standard, found that these 3 officers acted reasonably and they acted appropriately. And there is no distinction, there is absolutely no distinction in the law between the United States Constitution, the Texas Constitution, and the Texas Penal Code as to what reasonableness means. There is absolutely no distinction. Those 2 federal judges didn't let that case go to a jury. And with all due respect, Your Honor, I suggest that this court should not allow this abomination to continue and allow this case to go to a jury.
And to be explicitly clear, we're asking that the court grant an instructive verdict for all defendants of not guilty for all charges.
And yes, Your Honor, Mr. Cifuentes laid out all the facts, and I guess what I would just like to highlight is that, along with Mr. Del Prado in their argument, that as the court knows, you know, because I think there used to be a school of thought, not from this court, but there used to be a school of thought that, I mean, if the defense is bringing defenses, then the state has proven their elements of whatever they've proven. And there can't be a directed verdict. But I know, as the court knows, that the test is really, could a rational juror find, beyond a reasonable doubt, that the justification in this case did not apply. And so all those facts that Mr. Cifuentes has in his brief that he read, that laid out all the things we've gone through throughout this trial, where that culminates is that a rational juror, having seen and heard all of those things, a rational juror could not find beyond a reasonable doubt that the justification does not apply in this case under Chapter 9. You know, and in particular to Officer Alejandro, the state did not bring any evidence at all. They did not bring any evidence that Officer Alejandro actually shot Ms. Perez. And so without having that would put him in the same position as Officer Villalobos, which means that the murder, just on that basis alone for him, should be directed out. However, Sergeant Flores, as they talked about, as Mr. Del Prado discussed, Sergeant Flores, his charge of murder, it's the only testimony that was uncontroverted in the record was that he did not intend to kill, that none of these officers intended to kill. And I also asked the question, none of them intended to seriously hurt her. And they answered, and the officer answered that, the detective answered that he agreed with that, which would go to the second paragraph of murder, which is, you know, intend to cause serious bodily injury, committed an act clearly dangerous to human life, causing the death. That second part is, if they're not intending to kill her and not intending to cause her serious bodily injury, and that's the only testimony that the jury has, again, it goes back to the murder, both of the murder counts at a minimum should be directed out. However, the reason we're asking for directed verdict on all charges is because it goes back to, if the court as the gatekeeper can look at all of these facts and everything the jury sees, and if the court has seen, and if the court can decide, if any juror found beyond a reasonable doubt that the justification didn't apply, would that be rational? Could a rational juror find? And with everything that Mr. Cifuentes has read, a rational juror could not. With the state of the state's case as they have presented it, it is telling that as far as the justification goes, and we talked about Mr. Joyner being in the courtroom, Mr. Joyner has his opinion as to reasonableness, but he believed, and Mr. Joyner put in his opinion, that the officers were lawfully there and entitled to be there. The state had decided not to call him and went with a theory that frankly was never going to work because it involved a matter of law and a matter of mixed law and facts, which is only for the court to decide, which is how we got to this instruction. Their theory was based on that. Not once in the opening statement or throughout their witnesses while that theory was going, did we hear that they believed that their justification didn't apply or that the officers weren't being threatened with deadly force. I think that it was an acknowledgement that they were. And once the instruction went out that they could not rely on this failure to get a warrant in an unlawful arrest, that's when we started maybe hearing something about it, but still not necessarily controverted. The things that Detective Soto stated and the other witnesses that they called, basically every witness that they called, agreed that they were being met with the threat of deadly force. And then the things Detective Soto stated about the intent of the officers that he testified to and was not controverted is that they did not intend to kill, they did not intend to seriously injure Melissa Perez. And so with those things, as I said, the murder charges specifically should absolutely be directed out for what I said and the arguments of Mr. Cifuentes and Mr. Del Prado. But additionally, all of these charges, the only way it could go forward with the jury is if the court makes a determination that a rational juror, based on the evidence in the cases that they presented, could find beyond a reasonable doubt that they're guilty of any of these charges. And so that is why we're asking for the direct verdict on all counts on all defendants.
Judge, just to complete the record, but in the name of parsimony, we agree and join in all the arguments of counsel.
Your Honor, with respect to the arguments of counsel, talk about the federal court opinion, which of course is not final and subject to an appeal, but it's not an application of Texas law. And we've been through this argument multiple times or so. It's an application of federal law alone. It has nothing to do with even 931 and 932. Completely irrelevant, and it's not in evidence, and it's not for the jury to consider. That argument is specious, as Mr. Cifuentes likes to use. With respect to the elements of each crime, we'll start with Alfred Flores. Alfred Flores is charged with murder in count 1. That on or about the 23rd day of June 2023, he, with intent to cause serious bodily injury to an individual, namely Melissa Perez, did commit an act clearly dangerous to human life that caused the death of Melissa Ann Perez, hereinafter referred to as complainant, by shooting the complainant with a deadly weapon, namely a firearm. Those elements were not only perceivable on video, multiple videos that are before this jury, it was admitted to by the defendant in his written statement given to the police. This issue about whether or not his intent to cause serious bodily injury is judgeable by the fact that he fired 3 times into her abdomen or towards this person. And for him to raise self-defense suggests that he's saying, I did it, it's a confession and avoidance defense, I did it, but I was justified. A rational jury could find that he indeed did intend to shoot her, believing that was his means of stopping her from getting to him. That is not an issue in dispute whatsoever. Paragraph B is the alternative way of committing murder, is with intent to cause, intentionally or knowingly causing the death. An officer, and this is hardly worth saying, who's trained in shooting, who has a firearm, who carries it every day, is reasonably certain that death will occur if you fire multiple times at a person running at them. There's no dispute in the evidence that he did exactly that. It's observable and perceivable on video. And that he used a deadly weapon, namely a firearm, in doing so. With respect to the other charges, and I'll go more quickly through those, aggravated assault by a public servant. Again, no question from observing the video that defendant, Albert Flores, did intentionally, knowingly, and recklessly cause bodily injury to her. Bodily injury includes death by shooting her with a deadly weapon while acting under the color of his service as a San Antonio police officer. All those elements are proven without dispute. Likewise, the fact that he shoots projectile at her with a deadly weapon, not in dispute. Count 3, aggravated assault by a public servant by threat. He fired 3 times. He only hit her once. The other shots were certainly a threatening conduct towards someone who was aware of him, of her shooting at him with a deadly weapon. Count 4 was manslaughter, which we abandoned at the beginning, and that will need to be removed from the jury charge. And then finally, deadly conduct. From the evidence, it's perceivable that the defendant, Albert Flores, did knowingly discharge a firearm at and in the direction of an individual, Melissa Perez, and that he was a public servant acting under the color of his employer. Again, all those elements are proven, admitted to, testified to. Eleazar Alejandro, in the same way, he fired at her 10 times. From the evidence, they make a suggestion that there is no evidence that any of his bullets struck her. Well, it's before the jury, in fact, a video still that shows him firing right in the situation where her arm is raised, where the wound occurs, right there. And the medical examiner talks about the wound that Sergeant Flores fired, and we know that Sergeant Flores fired that wound because the bullet still in her body was a downward trajectory. We know that the bullet that struck Melissa under her arm was an upward trajectory. And just looking at the size of these 2 men, we can understand why one is downward and one is upward. And a rational juror can make that same determination that he had fired that bullet that caused her death. And again, there's no dispute about whether or not, just because he tried life-saving measures afterwards, that his intent in shooting at her 10 times, if he indeed perceived that he was doing so to stop her, was reasonably certain to cause her death. And the same arguments, the same evidence easily establishes that he knowingly discharged a firearm in her direction, and that all these things occurred in Bexar County. Nathaniel Villalobos is charged with 2 crimes. He's charged with aggravated assault by a public servant by shooting at or in the direction of Melissa Perez with a deadly weapon. Uncontroverted. Fired 3 bullets, observable from his video, into a wall where he could not see her, in which she was on the other side, slowly slumping down. A rational juror watching that video could say he missed her head by perhaps this much. That thing that they keep mentioning happened. That's what happened, missed her by this much, the bullets. And had she still been not received a fatal blow and could have survived, those bullets would have killed her. But for that, he is responsible for firing those bullets downrange. As Chernak says, every officer is responsible for any bullet that leaves their gun fired downrange. And he, in the evidence, knew that door was locked at the time he fired his shots. He knew it because you can see it on the video, him reaching for that door twice
I'll just ask
and
Mr. Limine to address the court.
One at a time.
Quit looking at my client in some sort of like dramatic fashion.
And I'd ask you to stop looking at our complainants when you're making your argument.
All right.
We already know that's
Yeah, let-
same as judge.
Same thing.
Let's hear the argument.
Anyway, Your Honor, that shows that that evidence shows a rational juror could find that he indeed knowingly discharged his weapon at an individual, Melissa Perez, while then and there a public servant under color of his employment sent to a police officer. So the indictment is proven. So the argument then is, and for the court to decide, is could a rational juror believe from the evidence beyond a reasonable doubt that the actors did not act in self-defense, they were not justified? Well, unlike a number of cases we have, they're basically testimony and swearing matches and credibility determinations. This jury has before it the whole event from beginning to her death. And they can see and they can hear all the officers. They can see what ultimately ended up being around 12 officers showing up to a situation that began as a property crime. And all these men, one woman, well-conditioned, trained, equipped with multiple devices, tasers, asps, shields, non-lethal force, less lethal force. They had all these options, the beanbag thing. And they were, because of the decisions made, particularly the decisions made by these three men, unable to take a 41-year-old woman, 47-year-old woman, 5'1", 140 pounds or about, into custody without killing her. That's for the conscience of this community to decide whether or not their actions in requiring and pushing the dominoes down to that result were reasonable. That an ordinary and prudent person would have made those same decisions that put them in the box where they felt they had to kill her. Yes, I suggest to you, yes, a rational juror watching all of that evidence, ignoring all the testimony, ignoring their statements, looking at all the video, can come to the conclusion of, yeah, this is not a justified killing. This woman should still be alive. And based on that, the motion should be denied.
Judge, just for one point, Ben, just for one point of clarity, Judge. There were 15 officers there, and so theoretically, since the Detective Soto was arguing the law of parties, under the law of parties, they're all guilty. That's number one, and we know that that's not the fact. Number two, when Sergeant Flores, as the evidence showed, Judge, and uncontroverted, and Officer Villalobos were setting up for this less lethal plan, the initiation was from, unfortunately, Mr. Perez. They didn't just come in there like a bunch of rogue officers just breaking in the door and just shooting. I mean, there was a plan. They were following the 5 C's. Uncontroverted. No expert testimony from them, nobody. Matter of fact, their lead detective agreed with, and the other detective also, on cross-examination, agreed with their behavior and the behavior, unfortunately, of Ms. Perez using deadly force, a hammer being a deadly weapon. Just wanted to clear that up. The judge knows, the court knows that, but I wanted to make those distinctions, Judge.
Your Honor, in response to the state's argument, and also to echo what Mr. LaHood said, I want the court to read part of Judge Bimperod's report, and this court still hasn't decided whether to take judicial notice of the opinion. I think that the court is within its right to take judicial notice of the opinion in this stage of the proceedings for this limited purpose. And if I may sit down and read from that opinion, Your Honor, on page 12 of the opinion, this is what Judge Bimperod says. An officer's use of deadly force is not excessive unless no constitutional violation occurs. I realize the state's going to say that doesn't address the Texas Penal Code, but the following part of the sentence mirrors the Texas Penal Code verbatim. Essentially, when the officer reasonably believes that the suspect poses a threat of serious harm to the officers and to others, and it quotes case law. Then it goes on to state whether an officer's belief to that effect was reasonable is measured in objective terms based on the totality of the circumstances as then known to the officer. And it cites Barnes v. Felix. Noteworthy at the beginning of this trial, Mr. Harris cited Barnes v. Felix to cite the proposition that totality of circumstances controls. Since Mr. Harris conceded that Barnes v. Felix and totality of circumstances controls, the state has essentially admitted that this analysis is what's controlling. What Judge Wimperod then goes on to say is, and this is an explanation of the totality of circumstances, thus the court considers the severity of the crimes committed by the suspect, and I'm going to pause, and the severity of the crimes here was several aggravated assaults against peace officers, attempted murders of peace officers, and the criminal mischief. So all of them together were a series of serious crimes that happened in the span of approximately 22 minutes. And then the sentence goes on. I'll restart the sentence just to be sure. Thus, the court considers the severity of the crimes committed by the suspect, any prior actions taken by the officer, such as giving warnings or trying to control the encounter. In this case, there is sufficient evidence to show that many officers asked Melissa Perez to come outside so they would not have to use force. They pled, they cajoled, they tried to de-escalate, they tried to unlock the door and so forth, but despite their repeated efforts to control the encounter, she refused. So I'm going to repeat some of the sentence and then continue. Any prior actions taken by the officer, such as giving warnings or otherwise trying to control the encounter. And then it goes on to say, the suspect's own conduct is always relevant because it indicates the nature and level of the threat she poses, either to the officers or others. So, under that standard, the totality of circumstances standard, which the state has conceded is applicable, and which the witnesses have testified officers are trained on, under that standard, Melissa Perez has shown that the nature and level of the threats that she poses by her conduct, by the 3 hammer swings before 20207, that she was in fact a dangerous threat to the officers and others. Then it goes on to continue. Of course, the situation at the precise time of the shooting will often be what matters most, but earlier factors may bear on how a reasonable officer would have understood and responded to later ones. So it's important for Judge Wimperod and for this court to note is under the totality of circumstances, yes, the moment of truth, the moment of shooting, the 20207 through 20215 is relevant, and there's undisputed evidence that she was threatening deadly force, and deadly force was imminent. However, when it says that earlier facts and circumstances may bear on how a reasonable officer would have understood and responded, the fact is that if you show an intent to kill someone by swinging a hammer at 2 different officers, a reasonable officer can conclude that if you try to kill 2 officers 3 times in a span of 22 minutes, 10 minutes before the shooting, that intent has remained unchanged. Moreover, she had yelled out many times to others that I'm not going to go back, you're not going to arrest me, shoot me, fight me, and so forth. The opinion goes on to say, the use of force is judged from the perspective of a reasonable officer on the scene rather than with the 20/20 vision of hindsight. And allowances must be made for the fact that officers make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. In this case, what we have is evidence replete with satisfying that what the department has done through Detective Soto's attempt to judge with 20/20 vision hindsight, but in reality, they didn't have 20/20 vision hindsight because they didn't see the facts correctly. And even 2 years and 4 months after the fact, they did not see correctly what happened with the benefit of hindsight. And even Detective Soto admitted that over the span of 4 months, he provided false information in his affidavit, false information in his prosecution guide, failed to correct the false information, did not obtain one of the videos from Travis Thompson until November 6th, after he turned in his prosecution guide to his command staff. Thus, there's no proof that he was even able to judge these officers with the benefit of 20/20 hindsight. So the court case goes on to explain, Judge Perez's court case goes on to explain that the officer's use of force was imminent, it was immediately necessary, and in later pages he talks about how when Melissa Perez was charging with the hammer at the officers, that any reasonable officer in the shoes of the defendants, as seen from their body cameras, that Judge Benperod, even he was able to see that the use of force was reasonable from their perspective. And since the state has failed to disprove beyond a reasonable doubt the justification of each defendant for all of the charges alleged against them, this court has no choice but to grant the motion for instructed verdict of not guilty on all counts for all defendants, and that's what we would ask the court to do. And Mr. Del Prado wants to address the court.
Just briefly, Your Honor, what I'm suggesting the court needs to zero in on with total alacrity to meet this new theory from the state is, at the moment deadly force, they were met with deadly force, was it their reasonable belief that they could use deadly force to protect themselves or another? That's it. The state, in their newest evolution of their theories, because the court has ruled out, I think as Mr. Cifuentes has pointed out, 4 of them up to this point, now they're getting into a public policy argument, which is not the law. They cannot cite any law to this court that says, oh, there should have been another plan. They should have waited. There could have been alternatives. That may be public policy, and for an office that was telling officers in this case that she would have been justified in killing them with a hammer, if that's the public policy that this district attorney's office wants to go forward with, then they can propose that. But that's not the law now. The law is Graham v. Connor for the country. The law is 932 under the Texas Penal Code. I would ask the court to have them offer up with specificity what law or what statute are you relying upon to make this argument that because, in their belief, another plan should have been called for. They should have waited. An attack, 4 deadly attacks aren't enough. You got to wait. It's, as the gatekeeper, Judge, we're asking you as the gatekeeper, because it's going to be too confusing and nebulous when they bring up this again. Well, and this jury may think, oh, well, I guess, maybe we have to. That's not the law. And I would ask them to specifically point out what law, what statute, what case law they're relying upon, because they will not be able to provide any.
And I want to reiterate what Mr. Del Prado wisely said and put it in this terms. The last argument that the state has propounded was public policy demands that. That may be an appropriate argument for a jury, but it is a gross improper argument to make to the court, because in essence what they're doing is trying to cower this court by making this court be fearful of what the DA's office may say by the court properly ruling upon the law. And because they have failed to disprove beyond a reasonable doubt the defense of justification, it's not this court's fault or responsibility to satisfy public opinion, and that's just shameful that they are trying to somehow or another cower this court, and I would hope that the court stand up to such a shameless argument.
I make no apologies for our arguments, Your Honor, on behalf of Melissa Perez and our community and the behavior of the officers in this case. None whatsoever. Your Honor, a rational juror could find at the time that these men jumped over into her patio or so, that all they feared was at a minimum bodily injury, and not serious bodily injury or death. They didn't have their guns pulled. They approached the door with their hands basically in their pockets, or they didn't have any guns in it. In their hands, and this is despite all the knowledge they had known before. So, despite all the hyperbole, Melissa Perez in no situation had tried to kill anyone. The most that she had done is thrown a candle, let me say without any wax in it, a candle at an officer's arm. That's not okay. But it's not an application of deadly force. It's an application of force. It's an application of force alone. You can't respond to an application of force with deadly force. The fact remains is she's behind a wall, a solid paned window, and an obstructed window on her left. And a rational juror can look at that and go, at the time they shot her, they weren't in actual danger of imminent bodily injury and death, considering her age, her size, her limited, having only an impact weapon or so. Given the manpower that they had, given the tools they had at their disposal, given that Officer Villalobos says, I'm not afraid of the hammer. Given Officer Chernak says, I'm not afraid of the hammer. A rational juror could decide that they were not actually afraid of serious bodily injury or death when Officer Alejandro overreacts and starts firing at her.
All right. I'll deny each of the defendants' motions for directed verdict. I will take judicial notice of the federal court opinion under Rule 202 for purposes of this hearing. Anything else? All right, let's take a short break, then we'll bring the jury back.
Judge, I did have just kind of a point of order. So we expect to begin our case. My understanding, I just want to make sure that everybody's on the same page. I believe that one of us will start our case in chief. The other two will be able to cross-examine the witness that one of us calls. What order did the court want that in? So, for instance, if it's our case in chief and Officer Villalobos' case in chief, if we start that, do you want all the defense to finish their questioning and then go to the state, or does it go to the state and back to the defense?
You know, Your Honor, it's been argued multiple times that it's a joint defense agreement. I don't believe it's
They have the right to
necessary for them or allowable for them to be able to cross every witness. It's not adverse to them. That would be my point.
They have a right to confront every witness that testifies.
They can confront. They don't necessarily be given the opportunity to lead.
Can it's not confronted?
And they should be given the opportunity to lead because it is a joint defense, but witnesses can say something that is more, I guess, more relevant to one than the other, and each defendant should have the opportunity to be able to confront any witness using leading questions. Of course, when it's on our case in chief, whoever's case in chief it is would have to direct the witness as would be common. But it's a cross-examination for every other person or every other part.
It's not a separate case in chief, Your Honor. It's a joint case in chief for the defense on a joint agreement. I know no authority for the proposition that Mr. Goss proposes.
It's the Sixth Amendment to the Constitution is the authority.
Do we all intend to go A, B, C, or just in a different order? Or?
Our idea is, I believe that our case, that the Villalobos case will direct the first two witnesses and then rest. And then the Sergeant Flores will direct the remaining witnesses and they will rest, and I believe that will cover the Officer Alejandro, and they will not have a case in chief, is the idea.
Okay, so then we'll do that. So we'll start off, and then as it relates to whether or not other defendants would be able to lead versus ask the open-ended questions. let me think about that for a couple minutes. Let me ponder that over the quick break and then we'll.
I just want to make clear that we're not waiving a presentation of our case in chief, but how, since we're going to adopt testimony of defense witnesses, to that extent, I would agree with what Mr. Goss is saying, and in the course of the trial, we would like to reserve our ability to call a witness and not give up that right to call a witness.
Yes, yeah, and we'll do that. I mean, each of the three defendants can present a defense and call your own witnesses.
Yes, sir.
So then the question for me becomes, is it gonna be joint defense, or is it gonna be the other defendants get to lead? So let me think about that one issue.
Yes, sir.
All right, let's take a short break. so just to make sure we're on the same page, so we'll go, so Mr. Goss, your side will go first? So it'll
Yes,
be.
we do have two witnesses.
All right, so you call your witnesses, and, I would say then that the state could cross, and then each other defendant can cross under the Constitution. The Sixth Amendment issues, I think, so.
And honestly, that's how I figured that it would probably go, and so I think we're on
Yeah.
the same page and didn't even discuss it.
Yes, it'd be direct, and then cross, and then cross-cross.
Very good. All right for the jury? May be seated.
All right, welcome back, members of the jury. We'll go through until one of you pretty much advises me that you're ready for lunch, and then that's when we'll take a lunch break, all right? And we'll try to keep lunch as short as we can today. All right, so when we last left off, the state had rested. I advised you, after I swore you in, that once the state has rested, then the defense, or defenses in this case, if they choose to, can put on a case for you as a case in chief. So with that, Mr. Goss?
I'm sorry, Judge, I believe Mr. Nisbet is going to open
Oh,
on behalf
you're
of
gonna-
Judge, I reserve, may I open to the jury?
Yes.
Thank you, Your Honor. Good morning. They had a duty to arrest. They had a right to go home. I want to thank y'all for your grace and your time and all your attention in this trial. It's hands down the longest trial I've ever done. Probably the longest one y'all will ever do. Okay? So in opening statement, I'm going to talk to you about what the evidence is going to prove. But the case isn't really over yet, right? So what the evidence is going to prove is on June 23rd, 2023, there was a call, officers responded. I know y'all know the facts at this point, okay? And the evidence is going to prove that really two things happened on June 23rd, 2023. Two things are going to be proved to have happened that day. A tragedy, where this young lady's family lost a mom, lost an aunt, lost a sister, and that's a tragedy, okay? But the second thing that happened was a rush to judgment. And that doesn't mean we have to have a second tragedy where these good officers are punished for self-defense. Mr. LaHood was very clear in walking y'all through this case that there were different scenes, right? The evidence is going to prove there was different scenes in this case, right? Chapter 1, Officer Rojas responds. He did not handle the scene, he did not handle the communication, and he did not handle Robert Ramos. The evidence is going to prove that, and that's a problem. Chapter 2, Jonathan Salinas arrives, and now you have felony assaults. The evidence is going to prove you have violent felony behavior on police officers. Melissa Perez was a very high risk. The evidence is going to prove that E-Tone was a 15-officer response, and the evidence has shown they only called 3. Finally, you have Chapter 3, where Alfred, Nathaniel, and Eleazar show up and attempt to arrest the suspect for multiple violent felonies. Melissa Perez attacks, and they fire in self-defense. Chapter 4, we brought you Detective Ronald Soto, and I'm going to try to keep a straight face when I talk about him, okay? He brought you his investigation. Mistakes, omissions, and errors. Now the judge is going to give you the law in this case. You'll remember in voir dire, I put up a picture of the judge and told you the judge will instruct you on the law in this case, all right? And he's actually already given you a very interesting piece of law. And so we're going to go through it because I know he read it to you all that one day, but sometimes it's hard to catch all of that legal jargon when somebody's just talking at you and there's so much information over 3 weeks, okay? You have heard testimony and arguments regarding the issue of whether the defendant officers were required to obtain an arrest warrant before entering the complainant's apartment. Okay, that's coming from the state. And as a general matter, whether or not police officers are permitted to enter a person's residence to make an arrest without first obtaining an arrest warrant is an issue of law for the court to decide, and is usually the subject of what's called a motion to suppress, which the evidence has been proving and y'all have heard a lot about. It is not an issue for the jury to decide in these cases. The evidence is going to prove that. Makes it real easy for y'all, right? All such evidence is irrelevant. You are instructed to disregard all the questions, all the testimony, and all the evidence related to the subject of whether these defendants were obligated to obtain arrest warrant, and are not to consider such evidence for any purpose. So now y'all have a complete picture of what the judge instructed you the law was, okay? But there's going to be more law that comes, and at the end of this case, the judge is going to give you the final jury charge, and that will say resoundingly that the burden of proof is on the government. Okay, the evidence is going to prove they have to show murder, the intent to commit murder, aggravated assault. They have to prove all that beyond a reasonable doubt, the highest burden we have. But they also have to prove beyond a reasonable doubt it wasn't self-defense. It wasn't justified. It wasn't defense of a third person. And that might get a little bit confusing. Sometimes when you're on a long journey, you can get lost in the time and lost in the details, but I need to remind y'all the evidence is going to prove, and the law is going to be, that burden rests with them the whole time. So if you find yourself thinking, geez, the defense are making a lot of good points, we don't have to. But we're going to show you in the evidence that it's so clear that we are bringing you the truth. And then we're going to bring you some defense witnesses. Not our burden, but we are. We're going to bring you a gentleman named Mark Sawa. Okay? Highly decorated major, SWAT, mental health, CIT training out of Austin PD. 7 years in the Valor program with the feds. Now is a use of force subject matter expert and instructor. Goes all over the country teaching police departments the right way to do it. Rewriting the way they do it. Mark can talk about use of force in OIS cases. Can tell you about Chapter 9 in the Penal Code. Can tell you about police investigations. I don't know why I'm holding this. We're going to bring you Mark Duke. Where are you, Mark? Raise your hand for me. There's Mark Duke. 28-year seasoned SAPD officer, retired homicide detective. 900 death investigations. It's a staggering number. 450 as the lead detective, 27, not the first, 27 officer-involved shooting investigations. Mark's going to tell you about how we investigate OIS cases. He's going to talk to you about the Penal Code in Chapter 9. He's going to talk to you about criminal profiling. Then we're going to call Lisa Miller. Lisa. There's Lisa. 28 years with SAPD, retired. Patrol sergeant, SVU detective, homicide detective. 21 years, honorable service, U.S. Air Force Reserves. Lisa's going to tell you about how you investigate a major crime. How you interview and then go into reporting techniques. And she's also going to talk to you about something that's really important. It's called confirmation bias, right? And how an investigation needs to be objective from the very start. You don't just walk up and have some concerns. We're going to bring you a gentleman named Ron Martinelli, who has had really 3 careers. He was a retired police officer. Then he did a series of special assignments with all the groups y'all see there. And since then, he's been a law enforcement training and police practices expert. Now, Ron's really interesting because he uses actual forensic criminology and the science of human factors. The science behind the OODA loop, right? I see it, I orient, I have to decide, I have to act. And he brings with him a gentleman named Angelos Liligalou. I hope I got his name right. Thank you. He does photogrammetry. A wizard at reconstructing and remapping through computer 3D real-time reconstruction
what it actually looked like in real time, what it actually looks like to the naked eye. A 50 millimeter flat naked eye lens will show you a view that looks very different from a concave fisheye body cam, which tends to distance and distort the farther you get away from it. Finally, we're going to bring you Thomas Butch Majeka. Butch, this man is the Santa Claus of law enforcement in South Texas, okay? A 47-year lawman, 33 years with SAPD, homicide, 2 years at the Bexar County District Attorney's Office on the Capital Crimes Group. Still working, 12 years, he's a lieutenant out in Kendall County. That's Bernie. He's going to tell you about homicides and OISs. He's going to tell you about the Penal Code in Chapter 9. The facts are going to prove that these gentlemen were justified. The last chapter of this story, members of the jury, it's going to be written by you. "847 days. These gentlemen have had to live with this. At the end of this case, we're going to come up here and we're going to ask, it's time to let them go home. Thank you.
Your Honor, we'll start with Officer Villalobos as in our case in chief, and we will call retired Detective Mark Duke.
Swear you in. You solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. If you could introduce yourself to the jury and spell your name for the court reporter, please.
Hi, I'm retired SAPD homicide detective Mark Duke. That's MarkDuke.
Can everyone hear okay? Can you tap on that? Okay. State, I'm sorry, defense?
Yes, Your Honor, and I know you probably said state because we're used to having Mark Duke testify for the state. Mark, you and I know each other because we've known each other for a decade or more. When I was at the DA's office, we worked closely on several cases that we had together, right?
That's correct.
Go ahead.
As a matter of fact, I've worked with every attorney at this table, and both Mr. Lunan and Mr. Harris as prosecutors, with the exception of Mr. Cifuentes, during my career.
And I want to talk about that career, and you heard Mr. Nisbet, you heard him talk about and kind of tell the jury some of your qualifications. I want to go into that a little deeper. So tell us first about the beginning of your career in law enforcement. How did that start?
Well, my first 15 years were on patrol. The last 7 years as a patrol officer, I was an FTO, a field training officer, which means I would train the recent graduates from the police academy and teach them how to apply what they learned in the academy to the streets. In 2010, I tested and was promoted to detective. I went straight to homicide. I was in homicide from 2010 till I retired in 2023.
And so the time that you spent in homicide, about 13 years, right?
Correct.
And in that time that you spent in homicide, tell us about the types of investigations and how many of those investigations did you do?
Homicides, capital murder, all suspicious deaths, overdoses, intentional, accidental deaths, suicides, anything that had the potential to be unnatural or criminal in nature.
And as far as officer-involved shootings, I know that you were here and you heard Detective Soto testify that he was assigned, his first one was this one. As far as officer-involved shootings, at the time that you were in homicide, was that common as well back then for somebody like you to also investigate officer-involved shootings?
When I initially went to homicide, we had a officer-involved shooting team. It only consisted of 7 officers. I think we had 14 or 15 homicide detectives, but only 7 of them were assigned to the shooting team. It became very burdensome because it didn't count in your rotation as being a homicide. So theoretically, you could get an officer-involved shooting one day, and later that day or that night, get a homicide case. So it became it was overwhelming. So they decided to extend the shooting team to every detective that was in homicides, that was working murders. So during the time I was in homicide, that changed from a 7-man shooting, officer-involved shooting team to everyone in homicide was on the shooting team.
In an department like the San Antonio Police Department, and you can answer based on your last experience, which would have ended in 2023, but in a department like that, how many homicide detectives are in San Antonio Police Department?
Well, to be a homicide detective is a pretty broad term. If you're talking specifically about how many detectives work murders, because some work ag assaults and threats and things of that nature, but homicide detectives only work things that have the potential to be a violent or criminal death. And when I first went to homicide, there were 2 teams of 7, 14 detectives. I think it has since grown a little bit. I would say I would guess there's probably been 4 more added. That could be 1 or 2 off, but I would say probably 18 detectives now.
Okay. And so going back to and one of the things you talked about was, being on a shooting team could be burdensome. So I want to talk about you said rotation. And so the jury might not know, but when you were there and there were 14, 2 teams of 7, explain how the rotation goes when there's a suspicious death and a case is going to be assigned to a murder homicide.
So we had 2 teams, 7 on each team. One team handled half the week, Sunday through Wednesday. The other team handled Wednesday at noon through Saturday. And within those teams was a rotation. If you're up for the next homicide, you catch every unnatural or suspicious death until you catch a homicide. On average, the suicide rate is 2.5 times that of the homicide rate. So you can expect to get, and San Antonio is a military city, so it's a little higher. The suicide rate is a little higher, so it's probably around 3 times the homicide rate. So you're going to pick up 3, maybe 4 suicides before you get your next homicide, and sprinkle in some accidental deaths and some overdoses. You may end up with 4 or 5 death investigations before you get your homicide. So it's very busy.
Sure. And just so that we understand that, just because something comes in and it seems like a suicide, you do a full and thorough investigation on that, just like you would any other case.
Well, you have to, because you only get one chance to collect the evidence. Once you release the scene, it's gone. So if you think it's a suicide today and find out tomorrow it's a homicide, unless you've done a complete at least collection of the evidence, you've lost things that you need for your investigation.
And so when talking about the shooting team, so if there were 14 detectives, but only 7 on the shooting team, what differentiates those 7 as far as being on the officer-involved shooting team?
Well, I would say experience has a lot to do with it, but I believe it also has a lot to do with the supervisor there who he wants on the shooting team.
Right. And so, I guess theoretically, unless, the supervisor's brother-in-law or something, you know what I mean? Unless there's some other reason, theoretically, the supervisor is going to put on that shooting team, investigating officer-involved shootings, the more experienced, the people who have had more homicide investigations, people who have had more experience with officer use of force and those types of trainings and things like that. Those would be the people that would typically be assigned.
Correct. Just to be clear, though, that's the way it was when I initially went to homicide. When this shooting occurred, all the detectives in homicide were on the shooting team.
Right, and that's kind of the point I want to make, is the way they used to do this, somebody like... Well, I haven't finished yet. So the way that they used to do this, according to what you're saying, it sounds like you're saying somebody like Detective Soto would never catch one of these for his first case.
That's the leading question.
Also saying.
Okay. Would somebody like Detective Soto ever catch a case like this for his first case in the way that it used to be run?
Well, I mean, theoretically, everyone has to have their first case at some point. So this could have been his first case, but you would want to make sure that there's someone certainly on the shooting team or that has a lot of experience shadowing him.
Right. And so, like, you were describing FTOs, like that you were an FTO. Can you tell us what that is?
Well, on patrol, a field training officer is an officer that is assigned a recent graduate from the police academy, and they've learned laws and a lot of tactics, but they've never really been able to apply that on the street. And it's a whole different world on the street. So your field training officer helps them make that transition from the academy to being a street police officer.
And it sounds like what you're describing, that's for patrol, but as far as like a shadow detective to help somebody with their first officer-involved shooting, would they operate similarly to like an FTO and try to help them and train them in how to do that job?
They would. There's no official designation, but yes, they would shadow them. Someone with experience should shadow them on quite a few cases, and normally they go out with them on call-outs. They would, and vice versa. They would go with whoever they're training with on their calls as well.
So in this case in particular, I called you and I knew you had been retired. I called you and I asked you if you would be willing to look at this case and tell me what your opinion is about the investigation and about some of the facts that we've seen. And you remember that I did that?
I do. He asked me if I would be willing to look at the case for the defense. And it's a funny story. When we were first here for the trial,
Object to non-responsive.
Well, let me ask. I can rephrase the question. Can you tell us what you were, when you were first here for the trial, what happened?
yes. One of the other experts, Lisa Miller, who I worked with in homicide, said, "You said you would never work for the defense." I said, "I did." And that's something I've said. That's something that I've never done. I never intend to do again. I'm very happy, retired, riding off into the sunset. But I did what Jason asked, and I said, okay, I'll look at it. And more as a favor to him, because we had worked quite a few cases, murder cases that were big cases, and they were very important. So as a favor to him, I said, I'll look at it.
Now, can you tell us what you were able to review? Basically, I gave you everything, access to everything that we had that the state gave us in discovery, right?
Right. I looked at the case, and I was very surprised at what I saw that resulted in the decisions that were made. And I felt obligated because of what I perceived as a huge injustice, and agreed that I would work with them on this case.
So I'd like to talk about that. In reviewing, did you review all the body cams that we had available from the officers that were on the scene?
I did.
Did you review the reports that were made available to you as far as the officers who had written reports, or reports that were generated like IDR, those other things that we've seen as evidence in this case?
I did.
And then you've been sitting here since the first day we were here, and you have seen all the testimony from the witness stand as well as the evidence that has been offered and introduced.
Yes.
Now, in your opinion, was this a thorough and well-executed homicide investigation?
No, not at all.
Okay. And in your opinion, was this a thorough and well-executed officer-involved shooting investigation?
No.
All right. So I want to start talking about that. And I want to take you back to the scene. So, from the perspective of somebody like you on the officer-involved shooting team, when you make a scene like that, tell us what you believe is important for somebody in your position if you were to make a scene as far as evidence collection, preservation, those types of things. Walk us through how that would happen if you were investigating.
So, the first thing that you've got to understand is you've got to collect all the evidence. You got one shot at it. And one of the things that I would always make clear to new detectives is I had a thing that I would do to try and make the point with them. The first thing you've got to do is you've got to collect all the evidence. And you know those 2-hole or 3-hole paper hole punchers? I would take one of them and go over to their desk and dump it on the desk. Made a big mess. When they were gone, of course. And I'd leave them a sticky note and say, you've got to collect the dots before you can connect the dots. That's very important. And you only get one chance to do it.
And so when we heard testimony that Detective Soto went and saw that CSI was doing CSI things, and as the lead detective just left the scene and didn't instruct them, is that a normal thing for a lead detective to do?
Well, no. First of all, if you're the lead detective, you're responsible for that case. You may trust the CSI, and we have very good CSIs. You may trust them, but ultimately, if they miss something, it's on you as the lead detective, okay? And it's your case that's either going to be made better or it's going to be insufficient. So, you we're constantly fighting the battle of, because we're human, of having preconceived ideas or being biased. So you're always having to make sure you keep that in check. I mean, it's just human. It's hard not to. But in this case, one of the things that should have been done, and I'll explain why, is the door that was broken into, it should have been fingerprinted. It should have been swabbed for DNA. The panel box where the alarm was should have been fingerprinted. It should have been swabbed for DNA. Well, why? She admitted to it. Well, it keeps people from later saying, Well, we can't believe what she said. She said she was Elvis's daughter. She said that she'd been kidnapped by the cartel, that she owned the building. So what this does is this gives us physical evidence that says, no, she did tell the truth. Her DNA was there. Her fingerprints were there. These are stone, hard, cold facts that we have to lean on if we collect the dots. In this case, they weren't. You can even go further and say that there should have been impressions made of any tool marks so that when we search the apartment, if we find tools, we can match them. That also shows that she's the one that broke into the alarm room and pried open the door. We could have collected the wires. We want to know, were they cut by a knife? Were they cut by opposing jaw cutters? Because if they are, there's tool marks on there that we can match any tools that we recover to that. So there's a lot of things that could have been done that weren't done that would have eliminated some of the guesswork on who did it or whether she was telling the truth or not. There was also things missing from there. We know that alarm box had battery backup in case the power went out, which is often the case in fires. But the alarm system would still work because it had battery backup. We found some batteries, about 13 of them, we know they were in the apartment. But there was one of the batteries, and you've probably seen it but didn't realize it, there's a cart right outside her front door. There was a battery. It's about the size of this box. Like a big neon sign that says, "This does not belong here. Why is this here?" Wasn't collected. It could have been fingerprinted that says, "This was taken by this person from this location." So we haven't even got to the shooting. And really, so is that important? What does that have to do with the shooting? Well, it was the whole justification of why the officers were originally called there.
Now, also, is it important, under the totality of the circumstances, that all of the facts and circumstances, like you're saying, about why the officers were there, what her state of mind was when they got there, and how that, what was going on, are all those things important to you and would they be important as a homicide or an officer involved shooting investigator?
Well, of course, all the details are important. I mean, you've got to have all the dots to connect them. You've got to have all the facts. To walk up and see shell casings on the outside of a scene and immediately say, "I've got concerns." There are many, many legitimate reasons that explain why those shell casings are outside. That's the bias we have to protect against. And we have to do a full investigation. And they take weeks. Sometimes they take months. I've had cases that have taken years to work through not just the evidence, but for people to feel like they could come forward. You don't give up on the case, but you want to be satisfied. You don't want to rush to judgment. So just to talk about the investigation, sometimes it's necessary to make an arrest right away. Is this person a danger to our community? Do we need to put them in jail right away for public safety? Is this person a flight risk? Are they going to go to another country? Those are times when you have to make quick decisions. That didn't apply in this case. These officers weren't going anywhere. Their whole career has been helping people. They're not going to hurt anyone. So when you make a...
I can ask another question.
Next question.
Could you continue, please, with your rationale for why these officers would not be a flight risk, and honestly, that there's no need to walk a warrant or put them in jail before a complete investigation.
These officers' families are here, their homes are here, everything they have is here. Why are they going to leave? They're going to wait and let the system work through this issue. And they're not a danger. They've never all their career they've helped people. I mean, that's what they do. When you have to make that decision to walk a warrant, you've got to have a good reason to do it, because there's two sides to every coin. If I make this decision quick, the payoff is I'm keeping this person from escaping and I'm making the world safe. But there's a cost of not being thorough. And you've got to let the evidence drive the case so that you don't have investigative failures. So the risk in making a quick decision is you may not get it right. But sometimes that risk is outweighed for public safety or to keep from them being a flight risk. In this case, there was everything to lose and nothing to gain. Everything to lose, what I mean is getting the investigation wrong. And by making it quick, there was nothing to gain. The reasons that we usually make that decision to do it quickly weren't factors. So there was no reason to make a decision in a few hours of what needed to be done with this case and the officers involved in this case.
And so, Detective Duthie, I think I know the answer to this, so you may educate me on it, at least in your experience. Like, let's say somebody starts a fire and it kills a person, intentionally starts a fire and then the person dies in the fire. I know that there are arson investigators, but would homicide also come out and investigate those as a homicide in addition to arson, or does arson just do the entire investigation?
Normally, arson will handle that, but until everything's worked out, arson and homicide will work it together. Sometimes the death was not a result of the fire. The death may have occurred before the fire, so there's some collaboration there. But normally, a fire death is investigated by arson.
So, and to bring that up, just so we can talk about it, like a case like when Ms. Villalobos was killed. Do you remember that case when that happened?
I
The
don't.
lady that was shot with.
Oh yeah, with the bow and yeah.
With the bow and arrow.
Yes,
Right.
yes.
So, and I think what you mean is that sometimes. Okay, I can ask you. I'll rephrase. So, just so we can set up the next question, what you said was that sometimes the death happens and it's not from the fire. So, have you in your experience had cases where a person was murdered and the fire was just like set to cover the murder?
Yes, and with the exception of retaliation, the greatest reason for arson is to destroy evidence of another crime.
So in that, I kind of want to bring that experience to bear when, as you're looking through this evidence and as a detective, kind of walking in the shoes of the investigation as it was done in this case, what concerns do you have about the fact that this fire alarm box, the wires were cut, and then the situation that was going on inside of Ms. Perez's apartment?
Well, in my training, I've been taught to look at things a little differently. I have 5 years of behavioral analysis training. And part of what we're taught is to ask the question, why? To look at the behavior at the scene and ask, why did the offender commit that behavior? The why leads us to the who. It tells us a lot. So, but the first thing I want to ask myself is, why did she cut the wires? There's a couple of explanations. One, maybe she was trying to keep these voices. She thought maybe the voices were coming through the wires. But maybe she had some other ulterior motive. Maybe she wanted to set the apartment on fire and for there to be no warning and no way to put it out. So these are questions that you have to consider because there are logical explanations as to why she may have done that. When you go to her apartment, we can see that there's at least 20 candles in the apartment. They're lined up on every windowsill. They were lined up on the bar. For some people, maybe that's just their prayer candles. Maybe there's a good reason for that. But she did use one as a weapon. There was one burning in the bedroom where the bedridden old man was. So you've got to wonder, why did she cut the wires? Why did she take the battery back up? Why does she have all these candles? What's the reason? That's one of the things that I would consider if I were investigating this case.
And as part of, if you were investigating, would that also, because, you know, we're putting you in the shoes of an officer-involved shooting investigator, would that also go into the totality of the circumstances, the potential risk to others in that apartment complex? Would those questions you're asking go to the totality of the circumstances of why the officers were reacting the way that they were reacting with Ms. Pettis?
Yeah, I think, having said all that, I think you're left with the question, is it safe now to leave this situation without taking action? And I think it's reasonable to say no. You can't leave this situation the way it is, just based on what we've spoke about up until this point. Not even discussing the assaults on the officers.
Now, we're kind of at the point where, you know, as we're following this investigation, we're at the point where, as Mr. Nisbet talked about, you know, there's those kind of three separate incidents. So we're still at kind of incident one, cutting the fire alarm, and then she, you know, ran away from a detention and ran back into her apartment. Were you able to view the behavior of Officer Ramos throughout this trial?
Yes.
And what is your opinion on his behavior and how he was acting with Ms. Pettis?
Well, he was kind of poking the bear.
Yeah. And because he did that, did you see any evidence in your investigation that any of these men knew that he had done anything like that to her?
No.
Right. So, as an investigator, thinking of those facts, would you charge what Officer Ramos did with Ms. Pettis to Officer Ramos, or would you charge it to them? Meaning, would you blame them for his conduct?
No, he has to take responsibility for his actions.
Right. And would it be fair for them to take responsibility for his actions, having no knowledge of those actions?
Of course not, no.
Right. So, we have that first scene, and now she's in the apartment. We go to the second scene with Jonathan Salinas. You were able to view Jonathan Salinas, Officer Salinas, attempting to go in the window to unlock the door.
Correct.
Okay, so what is your opinion of the attack that Melissa Pettis made on Jonathan Salinas when he was in that window?
Well, I mean, it was very aggressive. It was very dangerous.
Right. And in looking at that as an officer-involved shooting investigator, would you classify that as a homicidal attack that she made on Officer Salinas?
Could be, yes.
And when we say could be, the fact that she is attempting to strike him in the head with a hammer can cause his death.
Correct.
And so how does, for an officer-involved shooting investigator, just now that we talked about E-tone and everything like that, so how does that change the dynamic of what's going on out there by the time that these three men get there?
Well, it certainly escalated from a felony property crime to now we have an officer that's been assaulted, and it's become very dangerous.
And the candle You mentioned the handle that was used to strike him. Were you able to view and see from the video evidence, and especially as it was slowed down, how the mechanics of how she was able to do that?
Yeah, she was very accurate, very, it was well done.
And you're on that person, Marshall?
Yes.
I won't be here long. So, when you see in Detective Soto's report that says, that he said that these are the reasons he did not believe that it was reasonable for the officers to believe they were in danger, that window blocked by television, we went over it with him. In reviewing this evidence, would you agree with Detective Soto that window was meaningfully obstructed by the television that would stop her from her attack?
Well, obviously it didn't stop her attack. I mean, we saw that she went right around it and engaged the officers in the attack.
And what does that tell you as an investigator about her capabilities with the hammer?
That she's very capable.
And what could she do with the hammer if she were so inclined?
She could injure someone, specifically, in this case, the officers, if she wanted to or really tried to.
And based upon your investigation, would that window would that television or the open window have acted as an obstruction to her?
Obviously it didn't.
So as far as the E-tone in the totality of the circumstances, when Sergeant Flores and Officer Villalobos and Officer Alejandro arrived, should it be considered in the totality of the circumstances that they, as an officer involved shooting investigator, should it be considered in the totality of the circumstances that they are arriving because an officer was attacked?
Of course.
And when we say totality of the circumstances, and you say of course, and it's an obvious thing for you, but tell the jury why it's obvious for you.
Well, you have to consider everything, what they knew, what they didn't know, what would make what knowledge do the officers have available that makes them know whether this is where to kind of file this away as how big a threat she is. If she's already attacked someone, you've got to realize that she's capable of it. She's already demonstrated it. So you've got to add that in the totality. You've got to add that this window has already allowed her to attack the officers with no impediment. So you've got to take that into consideration.
So, in following on that, it's because getting into the mind of an officer or an officer involved shooting investigator, the idea is if that information, you would agree that if that information.
Object to leading?
Oh, I have to finish.
Well, he's saying I'm giving you facts and
I
asking you to agree. That's a leading question.
I wasn't. So it's harder for defense attorneys where we don't direct as much. Okay, so let's go back to because you're talking about the. I think what you said is you got to file it away about how big of a threat she is. Right? Okay, so why does it matter? Why would it matter to Sergeant Flores or to Officer Villalobos or to Officer Alejandro? Why would it matter how big a threat she is?
Well, so that they can decide how, I guess, defensive they need to approach this situation. Small threat and small opportunity, you can kind of relax a little bit. But if they have an opportunity and they have the means, you've got to really considered that this is a real possibility and that I need to be very cautious.
Right. And so just to kind of compare and contrast it, let's say the bedridden old man had a hammer with him in the bed, right? Would he present the same type of threat as Melissa Perez?
No.
And so would officers respond to him in the same way they responded to Melissa Perez, or in a different way?
Different.
Right. So at the part where we're here, at the second part, we're getting to the third part now, the third scene. They have arrived, and as far as when you're filing away and figuring out how big a threat she is, does that also, for an officer, does that also make them, does it matter, or I guess does it make them need to arrest more? Does it make the need to arrest more important, the bigger threat?
Well, yes. I mean, if you have someone that's a threat to public safety, you've got to keep the public safe. I mean, that's what the police are in the business of, literally public safety.
And so when we've heard through the trial that the officers weren't verbalizing any care or concern for the bedridden man in the apartment, as an officer, as Patrolman Mark Duke, 25 years ago, responding to a situation like that with somebody who is acting the way she is acting, if you found out that there was a bedridden old man, would you have concern?
You've got to, and the actions that were taken that day were partially in concern for the old man in the house.
And would you need to verbalize it to your fellow officers, or are you trained and are officers trained that in that type of situation, the concern is obvious?
Yeah, I think most reasonable officers that observed that situation and the way she was acting, the set of circumstances, the totality of everything would know that action had to be taken and that this other person's safety was in danger. They had to consider it. It's reasonable.
And as you would agree that officers' communication.
Object meeting?
Okay, I'll rephrase. Is officer communication important?
Yes.
And now, sometimes, are there things that officers don't need to communicate about because they already just know what it is based upon their training?
Yes.
Right. So, I guess, and that's what I'm kind of saying about this thing. The type of concern in that situation would have been obvious to a police officer with your training or theirs.
Sure.
Now, I want to talk about as part of the shooting taking place itself, as an officer-involved shooting investigator, what was important to you when you viewed the different body cams and the different angles, when you viewed their actions on that night when Melissa Perez was shot?
Well, I would want to know if their actions were reasonable.
That's right. And so, as you look through these things, did you find examples, as an investigator, did you find examples that would tell you that their actions were reasonable?
Yes, they were trying to talk her out. They were trying to give her every opportunity to end this peacefully. It was reasonable for them to recognize that she had assaulted other officers. I think it was reasonable for them to have concern about the old man in the other bedroom. So I think, I really feel like all their behavior was reasonable.
And so, in addition to the things you said, tell us about the preference, from your perspective, the preference of going against an unarmed suspect versus an armed suspect.
Well, certainly you would always prefer to engage someone that's unarmed if you can. And that would be your first choice and your priority to do so.
And so, did you note in your investigation and in your review of all these materials, did you note that there were times that Melissa Perez disarmed herself or unarmed herself by putting down the hammer?
Yes.
Were you also able to note, and from seeing the trial, that there were times that officers could see both of her hands and they did not contain a hammer in?
Yes.
All right. So tell us about your opinion about the reasonableness of trying to engage and make the arrest at a time when she is unarmed.
Well, so there comes a point to where you know the arrest is inevitable. It has to be done. The best you can do is to make it is to make that decision at the best possible time to give the officers as much advantage as they can. And if she's laid the hammer down, that would give officers more time than if she had it in her hand. I mean, it's reasonable to believe that it's going to take her time to close the distance to where the hammer is, pick it up, and then focus on the officers.
Right. And as far as we saw, do you agree with Detective Soto that Officer Villalobos had a reasonable belief that the door was unlocked?
Object to that, is being in violation of the motion, commenting on the officer's reasonable belief.
Well, I asked if he agreed with Detective Soto, which is in evidence, and he was able to view Detective Soto's
Elicited
testimony.
by them.
All right, so you can rephrase.
So I guess what I'm asking is did you hear Detective Soto testify that he believed Officer Villalobos was reasonable in thinking that the door was unlocked?
Yes.
Okay. Do you share that? Do you share that opinion at least with him?
Yes.
Tell us why.
Well, several reasons. We saw him unlock the door. We saw him communicate to other officers and his sergeant that he had unlocked the door. We see him go on the patio and put his foot against the door, believing it could be opened very quickly and easily. I think his actions demonstrated, and I think he verbalized his belief that the door was unlocked.
Now, that brings me to another part of the conversation we had with Detective Soto about what he could see on the body cam versus what the officers were communicating they were seeing on the scene. Can you talk to the jury about, I guess, maybe the perils of just viewing the body cam alone and not taking into account the other information?
Well, your field of view is very limited with the body camera. It only sees what's in front of it, and there's, if you turn your head to the side, a person can see a lot more than the body camera can. And also depth perception, when you're seeing it with your eyes, the depth perception of the camera, it makes things look much further away than they really are. And in reality, they're much closer. So depth perception is an issue, and your field of view is an issue with the body camera.
And were you able to see Officer Salinas and Officer Vince Gomez, discussing how close Ms. Perez got to Officer Villalobos with the hammer?
I did.
All right. So now let's kind of, you were talking about how officers communicate things that they're seeing, like Officer Villalobos communicated to a sergeant that the door was unlocked. As an officer-involved shooting investigator, when you have what you can see on the body cam, and you have what Officer Salinas and Officer Gomez are saying that they had just witnessed, which one do you go with?
Well, you would like a first-hand eyewitness account because of the limitations of the body camera.
Right. So, because when Detective Soto said basically it was just whatever he could see on the body cam, is that a smart way to do an officer-involved shooting investigation?
No, you're not factoring in a huge part of the evidence that you have available to you.
when Detective Soto said that he did not follow up with any of these officers or sergeants at the scene, the other sergeants at the scene, like, what is, in your opinion, is that a smart way to do an officer-involved investigation shoot?
No.
Shooting investigation? Yeah, and so tell us why.
Interviews with witnesses are very, very important. Just to give you an idea, there's only 3 ways to solve a crime: eyewitness testimony, confession, or physical evidence. Those are the only 3 ways. We know that only about 13% of the time do we have physical evidence that leads to solving a case and a conviction in law. So that means that 87% of the time, our evidence comes from eyewitness testimony or from a confession, our ability to speak to other people. That was overlooked. This is very, very important. We have got to talk to the eyewitnesses. And when you don't, you're going to have investigative failures.
What do you mean by investigative failure?
I mean, we're going to have a case that suggests someone is guilty when they're not. You haven't considered all the evidence. You've taken pieces, you've cherry-picked pieces of evidence and chose those that work in the favor of solving this case, but you're not really getting the true facts of the case. You're leaving some out. Police officers are some of the best witnesses we have. Why wouldn't you want to talk to them? Why wouldn't you call them in? You've had 2 years, over 2 years, to talk to them. Why wouldn't you? You know the limitations of the body-worn camera. They're good, but they're not as good as our eyes. And these officers all experienced this firsthand, and they weren't followed up with.
As a homicide investigator, your ability to interview people and ask questions that lead you to a solution, is that an important skill?
It is.
Would you say it's one of the most vital skills, as you quoted those percentages, is one of the most vital skills that a homicide investigator has?
If you're going to pick a skill, I would say that is more important than any other one thing, your ability to communicate.
Right, and so the fact that, we talked about it, so the fact that Detective Soto didn't follow up, that would be, according to your testimony, that would be a very unusual way to conduct a good officer-involved shooting investigation.
Yeah, at best, I mean, I guess politely it's lazy, and worst it's incompetent.
And so as far as and I'll tell you this, they don't deserve to be treated any better than anybody else, but you would agree they don't deserve to be treated worse either.
I think injustice until it's equally applied to everyone. And I think they deserve.
Judge?
Great.
All right, let's take it's already 12:53. Let's take an hour, 7-minute break, and come back no later than 2 o'clock. We'll see you then.
All right, to adjourn.
but I do want to talk a little bit more about CSIs and the importance of detectives, that lead detectives, giving CSIs direction. Okay, so you heard Detective Soto say, and we kind of addressed that. You heard him say, like, yeah, they were doing their thing, and so I left, and I didn't give them any instruction or direction. Right?
Right.
Okay. So can you think of a time in your career on a case involving three potential officers, well, three officers being potentially accused and charged of murder? And basically, so your officer-involved shootings, where you would not have given the CSIs one instruction or direction at the scene while you're on the scene?
No, I can't. And even at minimum, I would just go over what we were going to do just for clarification and just to touch base and go over what everybody's expectations were.
Sure. So I guess would that be like maybe you talking to the CSIs to see what they are doing or consider is important?
Yes.
Right. And then I guess checking that with what you think is important or what you need.
Right. I'm going to talk to everybody there before I leave and make sure I understand what's important, and then I'm going to make sure that CSI understands what I think is important. And see, it's a two-way street, and get some feedback from them what they think is important, because they're very competent people. We have very good CSIs.
You saw the CSIs that testified here in this trial.
Yes.
And you would agree that she does a good job.
Yes.
Both of them do.
Yes.
And so that brings me to the Leica scanner. We talked about Leica. Judge, may I have the witness step down, please, in a while?
Yes.
Could you come down here? So, I guess to start with, like a Leica scanner, that wouldn't be something that the detective operates. It would be something that a trained CSI would operate. Is that right?
Correct. They're trained. They set it up and they're trained. And usually it's done at every murder, not just officer-involved shootings, but generally it's done at every murder.
And could you just give the jury an idea of what it looks like? Like what is the, like, the way that the Leica looks and like how tall it is and what it's supposed to be doing?
It's usually on a tripod. It's probably about this tall, and it looks kind of like a camera that sets on there, and it's got lasers that go and shoots a beam out, and I'm not an expert, but it sends the beam and it bounces off of something, and the time it takes for it to come back, it makes measurements. And then it's set in one place, and it can do 360 degrees. Sometimes it's necessary to set it up in multiple places if you have a big scene, and it'll tie it all together. But that's kind of like it in a nutshell.
And so what's the importance to, like an investigator like yourself, what is the importance of having those measurements that the Leica would provide?
Well, sometimes it's hard to know what measurements you're going to need. If you run the Leica scan, you have it all. And then you don't have to worry about it anymore.
Okay. And you can return your seat. Thank you, sir. So, and I think that goes with the idea of you got to collect the dots to connect the dots.
Exactly.
Right. So, in this case, there has been mention that the Leica scanner that SAPD had was broken or wasn't operating on that night. So, even assuming that, are there other Leica scanners that can be made available from other police departments or other agencies?
Sure. I mean, agencies are always willing to help other agencies. It may not be a common practice, but we're always willing to help each other. I can't think of another incident that would be more important than when you have 3 officers involved in a shooting that you would want to document it than this one. And if you don't have one, you need to find one.
Right.
We-
And did you see in any of your review of all the materials in this case, or hear in any of the testimony, that Detective Soto made any attempt to try and go find a Leica scanner to get those important measurements?
No.
All right. Had you been an investigator and could not access the Leica because SAPD's was broken, would you have made every effort to find one?
I think you have to try. You have to call Bear County DPS, Ranger, somebody that's got one. I've never seen an agency not willing to help another agency, but at the bare minimum, the least that you would do is take very specific measurements of everything that's important, and that's at a minimum. That's really not satisfactory, but you would at least make the attempt of measurements that you know that are important, that were not taken.
Yeah, so, we've seen Mr. Nisbet with just like his tape measure that pulls out and, he measured off what 16 feet looked like here. Are you talking about at least have something like that and measure distances from window to couch to the end of the room and things like that?
Yeah, all the distances that are important, how much ground she covered and closed on the officers, how much room was between the wall and where that TV began to obstruct the window. We know that there's a couple of feet there because the officer was able to get in there with his wide shoulders, so we know that there's at least 2 feet there. I mean, these are all important measurements that were overlooked.
So, for instance, if you were going to put in an affidavit that there was a television obstructing the window, as an investigator, would you have measured and made sure that that was actually a true statement?
Well, if you want to be accurate, you would.
Right. So, as far as, I think you saw Mr. Nisbet's presentation, and one of the things that he said is that the only measurement we have is that 14-foot measurement of that wall there. It measured 14 feet, right?
Correct.
So, I guess what you're saying is as an investigator, there should be many other measurements that should have been taken.
Right, like where she was standing near the hallway to the door, where she sprinted to with the hammer. That's a very important measurement.
And I guess even measuring from where the officers were standing to where she ended up at the end, would that have been an important measurement?
Yes.
Why is that an important measurement?
Well, it talks about officers' training and what's reasonable. She's within that zone that we know is a threat. That's commonly known to be a threat within the 21-foot rule.
And so the fact that we don't have the measurements, or Detective Soto didn't have it, is that something that you would expect a CSI to know, or is that something that a lead detective should instruct the CSI to do?
The CSI probably, if they had the Leica scanner, would have ran the Leica, and that would have taken care of it. But since it wasn't working, he should have instructed the CSI personnel to make sure they got those measurements.
So and as far as like time and distance, if that is an important factor in this case, as well as their reactions, what they can see and perceive, those measurements are crucial to understanding that.
Absolutely.
Okay. So let's talk about the fourth scene. Your Honor, may I approach the demonstrative?
Yes.
And Detective Duke, I'm going to give you a copy of Detective Soto's affidavit for an arrest warrant. Now, to be fair, as a homicide investigator, you would probably be more likely than most to walk warrants based upon your factors of are they a danger and are they a flight risk.
Well, those are things you would consider, and if they were, then yes.
Sure, and usually because you're investigating somebody who
Just killed some.
just killed somebody. Also, as the flight risk, you would agree that people are more of a flight risk the more serious the crime they're charged with.
Correct.
Right. So, however, in this case, were these men a threat or a danger to anybody?
No.
In this case, were these men, in your opinion, were they at any risk of being a flight risk?
No.
All right. So I want to go to, we've talked about the third scene. So this is kind of what Mr. Nisbet talked about is this is kind of the fourth thing that's going on. This is the timeline. So, on this timeline, you can see that the decision to charge the officers, you heard the testimony that it was the meeting with Captain Van Geffen,
Correct.
according to Soto. Now, did you, in your review of the materials in this case, did you see a memo that Captain Van Geffen wrote about some of the circumstances that are going on here in the timeline?
Yes.
And what I mean by that is, from 5 o'clock in the morning to, I guess, till he met with Soto, there were some things that I guess he had done previously as part of the investigation, the homicide case.
Yes.
And you were able to see that.
Yes.
What was one of the things that was, I guess, more unusual that you saw that he did?
Well, the thing that's I think the most unusual is the amount of time it took for him to make the decision.
And before and when he was making that decision, who did he meet with?
Well, the family, and he met with the captain.
And I guess Soto did. Who did Captain
Yes.
Van Geffen meet with?
Well, he met with the DA's office.
Right, Civil Rights Division.
Correct.
Who do you know to be in the Civil Rights Division at that time?
Mr. Harris.
Okay. So, Captain Van Geffen stated, and you saw in your analysis of this case, that Captain Van Geffen at some point here, before the decision is made, at some point here was meeting personally, in person, with Mr. Harris.
Correct.
And they went through and reviewed body cam video.
Yes.
And he said, based upon that meeting, and I guess other meetings, they made the decision to charge at about 2:15.
Yes.
Okay. So now I want to go back to what you were saying, like the time. So let's talk about that. In this case, after I called you, and after you agreed that you would help these men out, and you would be an expert witness for us, and give your experience to the jury so they could understand this, how many hours do you think that you've spent retracing or going back over the investigation?
I don't know. 150 or more hours.
Okay, 150 or more hours. How much time did Soto spend before walking a warrant on these guys for murder?
I don't know, around 12 hours or so, yeah.
According to him?
Yes.
All right. Now, in 12 hours, you've reviewed body cams in this case, right? You've reviewed reports in this case, right?
Yes.
In 12 hours, would it be possible for somebody like you, an officer-involved shooting investigator, would it be possible for you to be able to make up your mind and have sufficient facts and data to make that kind of monumental decision for these guys? Would that have been possible to do in 12 hours?
I wouldn't have done it. I wouldn't have been comfortable with doing that, no.
Why not?
Because there's too much evidence to look at that needs to be considered.
And when you talk about that, the videos alone, just watching all the officers, you would agree that would take much, much more than 12 hours to do.
Well, yeah, and let me just give an example. If we had taken a little bit more time and just waited to see what was found at autopsy, we would have known that she was only shot twice. So that we know, if we had just waited, that we know that all three officers couldn't have shot her. Those rush decisions are what get you in trouble, and that's what causes investigative errors. You've got to have a good reason to make that decision quickly. Okay.
Those reasons, as you told us, is that they are dangerous or they are a flight risk.
Right, and in this case, there was everything to risk and nothing to gain. What are you gaining by making that decision quickly? You're not making the world safer. You're not keeping anybody from fleeing. So everything is at risk. The whole investigation is at risk by making this quick decision. Why? Why do it so quickly? Why not go over the evidence? Why not be thorough? Why not talk to everybody? Why do we need an arrest in 12 hours? There's no gain. All risk, nothing to gain from it.
And I want to talk about cases. As a detective, I guess, describe what would commonly happen after you have done your homicide investigation and you've decided, let's assume that you haven't walked a warrant. Maybe it's an older case or a cold case or something like that. But you have decided, okay, I believe that this case needs to be charged or forwarded to the DAs for review. Talk us through what happens after you complete your part of the investigation.
Well, if I've completed my investigation, I'm going to send it, I'm going to discuss it with the DA's office. If I'm going to walk a warrant, it's going to be after I've done a complete investigation. And then it's going to have to be approved by my supervisor. And then I'll file it with the DA's office.
Now, when you file it with the DA's office, in your experience and in your career, does then a prosecutor take what you have filed, review it to see if it's a case that should be indicted and carried forward further?
Yes.
All right. And have you had cases, you probably haven't had many, but have you had cases that a prosecutor has said, I'm rejecting that case, I will not file it?
There have probably been a couple. I couldn't tell you.
I would imagine, knowing your work, that you haven't had many of those. But have you known other detectives that they give it to the DA's office, the DA's review it, and they say, no, I'm sorry, we're going to reject that. That's not enough information.
Yes.
Now, have you also had cases where the DA's office or the prosecutors come back to you and said, Detective Duke, there's a few more things I'd like you to try to do. And could you do those things and then supplement the file?
Yes.
Right. And as far as, but you would agree that the normal part of the process is that you've done your investigation and then there's another pair of eyes in the criminal justice system that's looking over your work and seeing if it's sufficient.
Correct.
Right. But if the prosecutor and the Captain Van Geffen are both sitting there making that decision in 8 hours, then there's nobody over here on the other side, right? Like there's not, that other pair of eyes was already there on the front end looking at this and making that decision.
Correct.
All right. So, with the affidavit that you have up there, as an investigator, we talked to Detective Soto about it a little bit, but can you please explain to the jury why putting everything that you have that is material to your case and your investigation into the affidavit is important?
So, the thing that you may remember from the detective's testimonies, he said his goal was probable cause, or he just needed probable cause. And so what is probable cause? It's not, what that means is something is more likely to have happened than not. It means it tips the scales. Okay, it's really not defined in a percentage, but 51% would tip the scales. That would say it's more likely to have happened than not. So you have the right to write your affidavit, and your goal is probable cause, but if you write your affidavit with only probable cause, 51% is very subjective, and you may not really have probable cause, but the goal is beyond reasonable doubt. That's what the jury has to decide. That's what you have to prove in court. I like to be able to know I'm going to be able to show beyond a reasonable doubt unless I have some other circumstances that say I need to take action before I have it. There's got to be some payoff. There's got to be some reward for that risk. You don't have to put all your probable cause in there, but some detectives do, some don't. But what you do have to do is if there's any evidence that shows the person you're seeking this warrant for may be innocent, it's got to be in there. You may have 51% likely that it happened, but you may have another 20 or 30% that say he's innocent. Or there may be a good explanation which negates your probable cause. That's a little confusing, so it's really probably not a good example. But just to understand, you don't have to put all your probable cause, but you need to put everything in there that says this person may be innocent. And that's what was left out.
Right, and so for instance, because you would agree that all officer-involved shootings involve officers shooting somebody, or at least firing their weapon, but all the ones you would be investigating is somebody has been shot and sometimes died.
Normally, yes.
So So you'd agree that if you're investigating an officer-involved shooting, really the only thing that you're investigating that has merit or value is justification or not.
Correct.
Right. So when you see in an affidavit that Detective Soto wrote that he does not believe that these men were reasonable in what they did. They did reasonably shoot because there was a wall, a window blocked by a television, and a locked door between them. And you heard him testify to that.
Yes.
Okay. I want to ask about that. What are the issues with, let's talk about the locked door. What are the issues with him putting locked door without any other information about that door?
Well, it's not from the officer's perspective or what the officers believed. It's what the detective had the luxury of knowing after he had more facts or more information. So that's not an accurate description of the truth. I mean, yes, the door was locked, but that's not what we're judging the officers on. It's what they believed at the time.
And did you hear him testify that he believes, based on his review, that Officer Villalobos reasonably believed the door was unlocked?
Yes.
Okay. So, would that be something that he would need to put in the affidavit to try to get an arrest, that it was a locked door that the officers reasonably believed were unlocked?
To be truthful, yes.
Right. And just describing it as a locked door without the fact that describing glass panes, is that a material omission?
Yes.
And explain why that's a material omission.
Well, just like you explained before, that door is protection. It will protect you from a hammer, but a glass door will not. So you've got two different ways to describe this, and you can either describe it exactly as it is, or you can describe in a way that's biased.
And to you, does that seem like a biased description that ended up working like unfairly on these officers?
Of course.
And I mean, those are the three things he said that why they weren't reasonable. As far as the wall, well, let's go to the locked door also. Who controlled, who unlocked the door?
Ms. Pettis.
Right. And had she unlocked the door and gone through that door, could she present a threat in your training and experience?
Yes.
So and that wasn't anywhere in the affidavit.
No.
Okay. As far as the wall, so talking about the wall, were you able to see Ms. Pettis use the wall as cover?
Yeah, she used it to her tactical advantage.
Now, being able to use the wall as cover and then launch an attack from cover, is that reasonable for the detective to say that that wall was acting as, that wall was the reason that they were not being reasonable in their belief?
Yes.
So and as far as right, because when we're talking about the reasonable belief of an officer, or really anybody. I mean, look, how many homicide investigations have you done? You don't have to give me an exact number, but how many homicide investigations have you done where self-defense was an issue?
I would say probably maybe around 20%.
Right. And a number like that, when you're doing in the hundreds, it would equate to hundreds, right?
It could. Well, we average about 13 homicide cases a year over 13 years. That's 169 or so, and I mean, there are other death investigations, but as far as homicide investigations and officer-involved shootings, so I'd say 20% of those.
Okay, so
So,
a couple of dozen.
yeah.
And the only reason I say that is because it is important as a detective, as a homicide investigator, it's important to understand how self-defense works under the law, right?
Of course.
And because you have to take that and then you have to apply it to the facts that you have to see if this is a justified homicide or unjustified.
Yes.
Now, when doing that type of analysis, is it important to look and consider all the totality of the circumstances of why that individual did the action that they did that caused the death of another person?
Yes.
Right. And so I'm not just talking about officers, it's really because everybody has the same right under the penal code.
Right.
Now, have you had investigations where you've done that analysis and you've determined this person acted lawfully and justified?
Yes.
Right. And in that case, when you do that, you have to analyze it from the standpoint of that person and look at the totality of the circumstances, and then you come to your opinion.
Correct.
All right. So, you said you were a patrol officer and let's just, you talked, you've been over 100 hours doing this case. Just so that the jury understands, we went and asked the court to give money so that you could get paid for your time in this case, right?
Correct.
But we've never, and honestly, I don't think you've actually gotten any.
I haven't.
Right. But we've never asked you or paid you for any opinion that you have.
No, it's my understanding I was going to get paid regardless of whether I decided to do anything past reviewing the case or not.
Yeah, and that's correct. Because that's just like anybody, if you're going to spend that much time doing something, that it would be normal to compensate for that.
Correct.
Okay. So if you were the officer involved, if you were the investigator on this officer involved shooting, would you have been paid more or less for the work that you've done? If you were the actual investigator still at SAPD?
I would have made more per hour working as a detective than I've earned in this, yes.
Right. So, because I want to go into, you were a patrol officer for 15 years, and you have seen from every angle, you have watched these body cams numerous times. So, you understand what it is to have a duty to arrest, and you know what your duties were as a patrol officer, right?
Yes.
Under the law. Standing in the position of any of these three, would you have shot Melissa Perez that night?
Yes.
And is that based upon your review of everything that you have seen, that you believe that if you were in that position, that she would reasonably be perceived as a deadly threat to you or one of your fellow officers?
Yes.
And in that position, and from where she was, and seeing Mr. Nisba's presentation, and all of those other things, would you have perceived her threat to be an imminent threat?
Yes.
I'll pass it over.
Two quick questions.
Good afternoon. How are you doing?
Good. Thank you.
In the entire time that you were at the police department and thereafter, does SAPD conduct its own OIS investigations of their own people?
Yes, they do.
Is that really a best practice for the agency to investigate their own people, or is it true in most agencies a different agency would investigate the case? For example, in Live Oak or something like that, don't they have the Texas Rangers investigating the officer-involved shooting?
In some cases, they do. In big departments, us in Bexar County, we investigate our own officer shootings. But smaller departments that don't have the experience and maybe the equipment or expertise, they ask for help a lot of times from other agencies. I, as a San Antonio police officer, have investigated other agency shootings, and we routinely investigate shootings that occur in other departments. I think it has less to do with whether it's proper or not than the other agencies don't have the training and experience to do it.
Okay. Is there an issue of perhaps bias with the own agency looking at its own members?
I think bias is, and I spoke to this about the jury earlier, bias is something that we constantly have to keep in check. So I would agree there's always that possibility.
Okay. You had talked about collecting all the evidence, right? In a particular case, how important it is to collect all the dots before you connect the dots.
Right.
Wonderful expression, right?
I think it gets the point across, and that's the goal.
Okay. And that doesn't just go for homicide investigations or officer-involved shooting investigations. It goes for all investigations, wouldn't you say?
I would agree with that.
Okay. And when we talk about the rush to judgment that you're talking about, that Investigator Soto was involved in, when you were a homicide detective, did you ever meet with families of loved ones of victims of homicides?
Sure. That's one of probably the hardest part of what we do.
Right. And how many times did you tell victims in a case where you had probable cause that they had committed murder, that a person had committed murder of their loved one, that you were going to put off getting a warrant on them?
I don't recall ever having a discussion and saying I have probable cause. Those are things that I wouldn't reveal. I wouldn't reveal that normally.
Well, did you have a duty to get a warrant on someone you had probable cause for that had committed a murder?
I think if those two things that we talked about come into play, are they a continued threat and are they a flight risk, then yes, you have to sometimes make the decision to do that.
Well, you're hedging that, because you're talking about making a decision. The fact is you have discretion, right? Whether or not to seek a warrant on somebody, even though you have probable cause that they committed a crime. Isn't that the case?
I would agree that you can. I'm just saying, just because you can doesn't mean you should. You always should.
I hear you. I hear you loud and clear. Just because you can doesn't mean you should,
Correct.
right?
Correct.
And that applies not just to charging a person with a violent crime or deciding to have them arrested or charged with a violent crime. It goes with someone who's committed a misdemeanor, right? Just because you can arrest them doesn't mean you have to. Would you agree?
I believe that you have to, just the way you asked the question, I would agree with you.
Okay. So this issue about officers having no discretion to make arrests when they have probable cause is not true. An officer always has discretion.
Your Honor, I believe
Isn't that right?
that issue dealt with on felony arrest, and so for felonies committed, I think that's where the discussion was, not on misdemeanor, just to be clear.
All right.
What's your answer?
Yeah.
I would say that a general rule is officers are expected to act. I do know there have been occasions when officers have ran across individuals that had warrants for speeding tickets, and they've elected to not arrest, and officers have gotten in trouble. So there's a good chance you're going to get in trouble if you don't do what you're expected to do because of.
Okay, well, would you expect Detective Soto then to have gotten into trouble for not seeking warrants for arrest on people who were accused of murder on video?
I don't believe he was in danger of getting in trouble.
Okay, because there's no duty, right?
I think the duty is to make sure that if we're talking about justice, is to make sure you get it right.
Once again, yeah, I agree with you. So, with respect to Melissa Perez, okay?
Okay.
When officers made that fatal decision, ultimately, to go into her apartment to arrest her, they didn't have a duty to, did they?
I believe they did.
And you believe they did because she had committed a murder?
Well, because I believe our laws say that we have a duty to protect others.
Well, you just said you didn't have a duty to seek to arrest somebody charged with and you having probable cause for the offense of murder. Didn't you just say that?
That's a little different. It's discretion because you don't want to jeopardize the case. And then you're talking about public safety. So I think you always have to err on the side of public safety.
You have to agree with me that that's kind of a hard to believe that someone charged with murder is not more important to seek to have arrested than someone accused of cutting wires to a fire alarm.
Your Honor, I object to argumentative, and I do object to him keep conflating what they were doing with any cutting of the fire alarm. We've established they didn't get out there until she had tried to kill a police officer, one. But it's argumentative anyway, because Detective Duke has said that she posed an imminent threat to public safety. These officers did not. And so it's trying to conflate what he's testifying to.
You can rephrase it.
May I continue?
Yes.
Would you agree that the offense of murder and the actions of causing someone's death is a greater public concern than someone cutting wires to a fire alarm? Just tell me, what do you think?
If those are my only two choices, which is not the case we're dealing with, but if those are my only two choices, then I would say the murder would. But what we had is several assaults on police officers.
Okay, we'll get to that, but what I'm trying to get from you is your honest answer about, or that officers do not have a duty. Do not have a duty, even though they have probable cause that someone's committed a criminal act, they do not have a duty to arrest them. Can you at least agree with me on that?
No, I think we do have a duty.
Oh, now you're saying we do have a duty. So Detective Soto did have a duty to get an arrest warrant for these three men.
You're mixing the two.
Yeah, one's murder, and one's cutting wires on a fire alarm. I just want you to kind of reconcile that.
I'm going to object to this scenario because there is a difference between when you're authorized to make an arrest without a warrant, when an offense is committed within view for certain felonies, and the requirement to get a warrant when it's not committed within the view. And so he's failing to distinguish between the two.
May I continue now?
Yes.
And I'd like a ruling on the objection.
If your objection is that the offense was not committed in their presence somehow, that's,
He's creating a false scenario.
okay.
And it's
So the
misleading.
creating the false scenario,
And it's misleading.
I will sustain that.
Okay, well, in each situation, on a case where you have probable cause that a person has committed a felony, outside your presence or view, okay? You follow me so far?
Yes.
You don't have a duty to arrest either person, right? You have discretion to decide whether that person is going to be arrested, you as a peace officer.
Again, that's a misstatement because his scenario requires that an affidavit be presented to a judge and the judge sign finding that there's probable cause. And until the judge signs the warrant, there is no duty until the warrant is signed. So it's a false scenario, false assumptions.
All right. I'll overrule and I'll let the witness answer.
I believe that we have a duty to arrest. And if I am still investigating a case and trying to get all the evidence, I don't think I'm obligated to make that arrest till I've gotten a warrant and I've convinced a judge who's a neutral party to agree with me. There are cases in a murder when maybe it did take place in front of a police officer that you don't have to wait for a warrant, but that's a different scenario than we're dealing with.
I'm just kind of following up with your testimony about how important it is to collect all the dots before you can connect all the dots when you're doing an investigation, right?
Yes.
And that you wouldn't want to arrest someone before you've connected or collected all the dots. Is that right?
I would agree. I agree.
You agree, okay. And would you say that the officers in this case, with respect to the investigation into what Melissa Perez allegedly did, spent less time collecting the dots before they decided to arrest her than Detective Soto did spend time collecting the dots before he decided to arrest them?
In this case, they had all the dots. She had assaulted the officers right in front of them. What else is there to collect?
I'm talking about before that.
They object to talking about before that because these are police officers that are still on the force, that have not been charged. Like, all of the stuff that those guys did had nothing to do with what these guys were there for. And so I think keep bringing it back to something that's not relevant is irrelevant, and that's why I object to it.
You're on prejudicial under 403.
I'm only following up on his questions of him insinuating or claiming that these officers had a duty to act when those same rules don't apply when he compares it to Soto's actions toward these officers.
Let's not conduct a 403. I'll sustain the objection unless the state can indicate that these officers were out there actually investigating.
Okay, what I'm talking about is just the standard of the duty. I'm talking about the criticisms of Detective Soto in deciding to arrest somebody, okay? Compared to what they had on Miss Perez, where they decided to arrest her and said they had a duty, and they're claiming that with Detective Soto that he had no duty and should not have arrested him. This is a defense of what they say was a rush to judgment by Detective Soto when it doesn't work both ways.
But the duty comes from the fact that she made herself a risk to public safety at that moment. So they had a duty to go in. She'd assaulted. These officers were not a risk to public safety. So therefore, that's the difference, and that's why we're saying that is confusing under 403. It's confusing the issues to the jury.
I think the jury can decide whether or not firing 16 times into a woman's apartment is a bigger risk to the community, her neighbors, the man next door,
All right,
than the other actions.
The court conducted a 403 and sustained it. You can ask your next question.
You talked about the actions of Melissa Perez that you could observe on the videos, and you characterized her actions toward Officer Salinas as a intent to kill him.
Well, I think there, at first, I think there was multiple events. I think one, it was to injure him, and on other occasions she attempted to seriously harm him or kill him, yes.
Okay. Well, would you agree that her purpose in running him away from her window was to keep her out of her apartment? Would you agree with that? Sorry, what's the objection?
Speculation is to state of mind. What her purpose was.
If he doesn't know, he can answer that.
Would you agree that her purpose in running at that Officer Jonathan Salinas was to prevent him from entering her home?
I don't agree.
You don't agree with that?
No.
Okay. Would you agree that her purpose in taking the hammer outside the window and moving it back and forth at him was sending it as a threat and a signal to him, don't come back into my home? Would you agree with that?
Objection, Your Honor, is irrelevant given the court's ruling on the fact that 38.03B does not give a person the right to resist arrest. And we've already had rulings on 9.41 and also rulings on the Castle Doctrine and other rulings, and this is improper.
I'll allow the question.
And then also the state objected to any expert opinion about a state of mind of the other, another. That's exactly what he's asking.
No, I'll ask about the state of mind of the defendants.
You can rephrase your question.
You watched the video in which, after Officer Jonathan Salinas withdraws from the window, right? You remember that?
Yes.
You watched that?
Yes.
Right. And in that period of time, she puts her hand out the window and moves the hammer kind of back and forth, right outside the window. Remember seeing that?
I believe she swung it at him.
Okay. It wasn't at him because he wasn't at that location. She was making the gesture in. Is that right? He wasn't in that spot. She wasn't within reach of him when she did that. Would you agree with me?
I believe it was an assault on the officer.
An assault by contact? An assault by
I think
threat? An assault by what?
I think using a deadly weapon.
Okay. Was it an attempt to kill him?
I think it could have been, yes.
Okay. Do you believe that as much as do you say that with as
much emphasis you do the rest of your testimony that you are confident that she was trying to kill him at that moment?
I think she was willing to do whatever she had to do to not go to jail.
Okay, and then she followed that up with what?
She threw, well, there was a couple of times, a couple of assaults with the hammer, and then she threw the candle at him.
Okay, and you said, I'll get your quote here, she was very accurate in throwing the candle. Is that what
Correct.
you said?
Correct.
That's what I wrote down as your quote. Did I get
Right.
that down correctly?
You did?
Okay, meaning that she was aiming at what she hit.
Yeah, I've got to believe that, yes.
Right? I mean, isn't that what it means? If she was accurate in throwing the candle, it means that she hit what she wanted to hit.
I believe so.
Right? Okay. And would you agree that her striking him with the candle in the arm was not a exhibition of deadly force? Only force,
Agreed.
right? It did not cause him bodily injury, or serious bodily injury, right?
Bodily injury, but not serious bodily injury.
Right. And not death.
Right.
Right? And in none of the videos that you saw, did she express to anyone standing outside those windows her intent to harm any of them? Did she?
Not verbally, but her actions did.
Oh, I asked you if she expressed it to anyone.
Yes, her actions
It
did.
can be verbal and nonverbal, so this is argumentative.
Okay, I'll ask you first if she expressed it verbally to anyone surrounding her in the entire time that officers were surrounding her apartment. Did she express her intent to hurt anyone?
I didn't hear it verbally, no.
Didn't hear it, right?
Right,
And then you listened to all of it, right?
right.
Right. The only time that she expressed in nonverbal terms her intentions to cause someone injury was when they tried to go into her apartment. Would you agree?
Yes,
The only time.
yes.
And she, other than hurting Salinas by throwing that candle at his arm, she didn't hurt any of the other officers the entire time during that whole ordeal. Would you agree?
But she attempted to, but no one was harmed, luckily.
Well, let's talk about the Villalobos entry, right? Where Officer Villalobos leaned into the window at 151 thereabouts, right? You know the moment I'm talking about, right? His first leaning into the window.
When the other officers told him to watch out, watch out.
Right.
Yes.
The officer told him to watch out, and he fully extracted from the window to the side behind the wall, right?
Yes.
And then you can see her running up to the window, right?
With the.
Am I right?
Yes.
Okay. I mean, how many camera views did you see that through? Body-worn camera views.
I don't know. There were multiple.
There were multiple ones, right? And not on any of them did you see her with the hammer raised, with the hammer swung, with him being anywhere near her hand and a hammer. Would you agree?
No, I think he was. I think he was. She was near him with the hammer.
I'm sorry?
She was near him with the hammer.
How close was she then when you say near him? Give me an estimate how far away he was.
He was on the porch, so it was certainly within 6 feet, 5 feet.
Okay. 6 feet. But did you see her with that hammer raised?
Well, she swung it.
Oh, did you see her swing it? In fact, you didn't on any of the videos see her swing that hammer. Am I right?
Yeah, I can't say for sure.
That's pretty important, isn't it? I mean, in all the reviewing of the videos you saw, would it be important for you to have been able to pinpoint a time when she swung or threatened Officer Villalobos with a hammer?
Well, we know she did. Or his head was in the door, and she was running at him with it. So he was He was in danger.
This is 10 minutes later you're talking about?
It was before. Oh, Villalobos. I was thinking of.
Villalobos. I'm
Okay.
talking about Villalobos.
Yeah. Yes.
Right. So would you agree with me then that there is no video evidence from multiple videos, from multiple body-worn cameras, of when Villalobos is extracting himself from the window, that Maria
Perez, Maria Perez, Melissa, swings a hammer at him or is anywhere close to threatening him with a hammer? You don't know?
I'm not
If you don't
sure.
know, that's fine. And in the seconds and minutes that follow, what does Villalobos do then?
Well, he backs out.
Okay. Well, first of all, he stands. May I, Your Honor?
Yes.
He stands in the patio, right? With the window here, and the wall here, and the door here, right? And he has his foot up against that door. Would you agree with me?
Yes.
Right? And his back to all of this, right? And you can hear the voices from the other officers. So does she have the hammer in her hand? What are the officers saying?
They were telling him to watch out.
They were telling him to watch out because she has a hammer in her hand, right?
I believe so, yes.
And he's not even looking. He's not even afraid, is he?
Judge, I'm going to object to whether or not he was afraid. He had other officers that had lethal force trained on her and figured that out. So he knew that he had that cover while he was standing there on the porch. So that's the state of mind. He's trying to go to the state of mind of my
I'll
client.
withdraw that question, Your Honor. I'll withdraw that question. He's standing there, though, right? Who's in control of whether that door opens?
Well,
Who is in control of whether that door opens?
I think you could argue either way,
Between who and who?
between the officer and Ms. Pettis.
Do you believe, based on your training, your experience, you're watching those videos, that Melissa Perez could have opened that door with Nathaniel Villalobos having his heel against it?
I think you could make the argument that she could have.
Her 130, 140 pounds?
Running at full speed and turning the knob and pushing it open. I think you could make that argument.
Okay, would you make that argument?
I'm suggesting it, yes.
Go. Officer questioned you about the lit candles in her apartment. Do you remember that?
Yes.
Okay. Is it your testimony that the reason why officers had to urgently go into that apartment was to extinguish those lit candles in there?
I'm saying the totality of everything. Why did she cut the fire alarm wires? Why did she have candles? I think one has to ask themselves, what is the reason for that? Is there a risk that she could start a fire?
Who needs to ask those questions?
We do if we're trying to get to the bottom of this situation.
The officers at the scene, did they need to ask those questions?
I think it's something that they have to consider whether they're going to leave her there or not.
Okay, you're engaging in 20/20 hindsight, right? Kind of be looking back at it, because that's all you can do.
I'm going to
Right.
object that he's the one asking him to consider things in 20/20 hindsight, so it's argumentative for him to suggest he's the one asking him to do 20/20 hindsight, when it's the state asking him to do 20/20 hindsight.
I'm only responding to questions that they had asked him
This
on
is
direct.
argumentative and improper.
All right, I'll let you ask the question.
Okay. Do you believe, from the videos that you watched and the statements you've read, okay, that any of those officers making entry in Melissa's apartment were doing so out of concern for the lit candles?
I don't know. I'm saying I would have been concerned.
Okay. You would agree, though, that there is nothing from the evidence you saw. Did you see every video?
I think I did.
Okay. I mean, how many hours are you billing for having looked at the videos and everything?
I'm not billing hours.
You're not billing any hours?
No.
You're just billing a regular, one amount?
Yes.
And is that based on your review and your testimony, or did you make more from testimony plus your review?
It's my understanding, I just got paid to look at the case. I don't know, I'm not getting paid more or less whether I take it or I testify or I don't.
Okay, okay. But you can't tell us how many hours that you spent looking through the videos?
No, I mean, I haven't been keeping track of it because it doesn't,
Haven't
no, because it doesn't matter. What's the reason?
Okay, okay. So in any of the videos that you saw, would you agree that the videos encompass the entire event of the contact with Melissa from the time that she was talking to the fire department folks until well after her death?
Most of it.
Most of it? I mean,
Yes.
it covers the entire time period, right?
It doesn't cover her for the entire time period, but it covers the time span.
Okay. And would you agree that during that entire time period, there wasn't one voiced concern from any officer about the lit candles in her apartment?
I didn't hear any, no.
And did you, in any of the videos that you saw thereafter, them going through the apartment, blowing out candles out of their concern for the lit candles being in the apartment?
No, but you can clearly see candles burning in the apartment and then later they're not.
Yeah, as they're walking through, they're doing life-saving measures, there are candles burning, and everyone, it's not important, right?
Well, at that point, it's not.
Yeah. Yeah. The window, right? We talked about the window and how obstructed it was, or not obstructed it was. From what you could view from the video, on watching the various angles, could the TV that was in front of that window have been moved or pushed over by someone's hand?
Could it have been?
Yes.
I didn't see that happen.
It did not happen. I agree. Well, you, like me, maybe not as much like me, remember TVs when they were big old heavy structures, and now they're not, right?
Correct.
Okay. Would you agree that someone could have taken their hand and moved that TV away from the window?
And us not seen it?
No,
On body cam?
No, I'm saying, could officers have taken their hand and moved that obstruction away from the window?
You mean if they wanted to make entry? I'm not understanding your question.
Well, instead of Villalobos reaching through the window to unlock it, could he have more easily taken his hand and pushed that TV out of the way from obstructing that window?
Yeah, I don't know how heavy the TV, I'm not sure if that could happen or not. I mean, maybe, I don't know.
And what would that accomplish if he had?
It would have alerted her because it would have made noise.
Okay, and then what else would it have accomplished?
Well, it would have removed any restriction that it may have caused.
And would that removal of the restriction made it easier to maybe tase her in her front room?
It may have given them more access to her, but you still have the issue of going hands-on with her.
Would it have provided a clear shot for a beanbag shotgun to train on her?
It could have. There's limited space on the patio, but maybe.
Okay. Could a shield have warded or protected an officer from any serious risk of serious bodily injury or death from a hammer?
I think the shield was a poor choice, and I think it would have complicated things more than it would have helped things.
Well, if you'd have taken the shield, if you were afraid of a hammer strike, if you were aware of a potential hammer strike and you were afraid of a potential hammer strike, going through a window? Could you have taken the shield and put it up against the window and tried the door? Would that have removed all concerns of serious bodily injury or death by having that shield against that glass?
No, because she could have come around the shield.
You don't think that an officer would feel safe from serious bodily injury or death if he was in possession of that shield and all she had was a hammer?
Objection asked and answered.
It's a different question.
Overruled.
I don't think that's appropriate application of the shield.
Would you agree with me that had there been any realistic fear that Miss Perez would hurt the old man in the next room, wouldn't you expect, with the abundance of officers that were there at the scene, I think up to 15, that someone would have been assigned next to that man's window to look after him? Would you think that would be the reasonable choice?
Well, she had come to that room several times. I don't know that would.
Okay, you mentioned seeing in the video she had gone to that room several times. Each time she went to that room, did officers rush to that window to protect that old man?
I don't think they did, no.
Not once, right? Not once, right? And then there's a time right before the entry of Villalobos reaching into the window, which you can see this on Rojas's video, right? From his body-worn camera, you can see the video into the room where Santos de la Rosa is. Remember that?
Yes.
And he's narrating as this is going on. And he says, look, she's coming, she's got the hammer, and she goes into the room with Santos de la Rosa with the hammer in her hand. Did you see that?
Yes.
Does Officer Rojas immediately or at all go to that window? Go to Mr. de la Rosa's aid?
I don't think so.
He does not, does he?
I don't think so.
And Dylan Young is standing right there too, to the left of Officer Rojas, and he sees this. Does he show any concern for the old man by rushing that window out of fear for what?
Objection. The state's motion in limine asks that witnesses not testify as to the state of mind of another.
I'm asking about their actions.
No, he's asking about their state of mind.
Ask them about their actions.
I'm asking about their actions. Did they rush? They rush into that window.
I don't recall seeing them do that, no.
They didn't, did they?
I don't think so.
Did you see in any of that video on body-worn cameras any officer take any actions to stand over and protect Santos de la Rosa?
No.
No. How many officers were there again?
13, 15, something like that.
Were they all engaged in more important matters than that?
Well, they were trying to come up with a plan to make entry so that,
Okay. Were there enough officers around that one of them could be spared? If that indeed was the reason why they went into that apartment, was there one officer that could have walked over to that window and guaranteed that she wasn't going to hurt him?
they could have.
They could have, right?
Yes.
Okay. If they believed it. Would you agree?
You're asking me to say if they believed it or not. I don't know.
I know. But if they did, wouldn't you expect that action from your San Antonio Police Department?
Your Honor, it's just the reason I'm objecting is because there's a difference between they're all there and they can see her, they can see the window, they can see all this stuff. What Detective Duke was talking about is they're all like leaving and leaving her alone with this old man, and that was the concern. So I think it's conflating these two issues, and under 403, I believe it's confusing the issues, and so we object on that basis.
All right. I'll overrule the 403, and I'll just make sure the state asks questions related to that issue.
Detective Duke, when you were still with the San Antonio Police Department in 2022, did you attend the in-service?
Yes.
No object to this line of questioning. This gets into our objection that we filed, which the court ruled in our favor. This was improper. It's in the tactics. This is a course that was not TCOL certified, and not everybody attended it. It's not relevant. Not all of the officers attended it. It's not relevant. And we know that it's going to ask questions assuming facts that have been proven not to be true. This course is inapplicable to situations where someone is engaged in criminal conduct, is armed, and is not alone. She was with someone, she was armed, she was not suicidal, and she engaged in violent criminal action. So this line of questioning is inapplicable. And as we said, it was not TCOL certified at the time it was taught. Didn't become TCOL certified until June of 2025.
Your Honor, I'd just like to make a note that in respect of the court's ruling in Limine, I didn't ask any of these questions about that. We stuck to the investigation and how the investigation went. I would have asked those questions before Mr. Limine was able to, but I was in respect of the court's ruling.
All right, so I just caution the state to be careful with any doors that might be opened on that.
Understood, Your Honor. I'm trying to address, you testified at length about whether or not the officer's actions were reasonable. Would you agree?
Yes.
Okay. Your basis for making those decisions isn't simply your own personal experience. You've been trained, haven't you?
In the law of what they can reasonably do and can't.
Yeah, haven't you had training on how to deal with people who have barricaded themselves in their house and the use of force and the use of de-escalation? Haven't you been trained in those things?
Judge, with all due respect, de-escalation and barricade has nothing to do with Chapter 9. It's not referenced in Chapter 9 at all. And it's a policy, not a legislative statute or provision that either changes or modifies justification. So to suggest that barricading training and de-escalation training has anything to do with whether or not force was justified at 20207 and at 20213 is disingenuous and inapplicable.
It does have to do as to whether he's qualified to testify to the conclusions he's making. That's the purpose.
Well, if he wants to do that, then he needs to attack his credentials and his resume, not some bogus theory about what the law is or isn't, when clearly it's not the law. De-escalation and barricade has no part of Chapter 9, and SAPD policy is not the same as penal code.
All right, so if you want to examine whether he's qualified to testify to his conclusions and ask him that specifically.
Okay. I'm asking you, did you attend that tactics and service, technical response and disengagement for
Same
barricades?
objection. Same objection.
I'll sustain.
So what is your basis then for being able to say whether these officers' tactics, these officers' observations were reasonable if it wasn't for any training?
I'm going to object to him interjecting the word tactics, because tactics has no bearing on Chapter 9, and to suggest that tactics can vitiate justification under Chapter 9 is a misstatement of the case law and the statutory law, and this is a repeated violation of the court's rulings, and I'd ask that counsel be instructed not to ask any more about tactics.
All right, State, you can refer.
Should just mark it again.
Armstrong?
Yes.
There, you've got it in front of you here, but I've got a marked copy of it. State's Exhibit 197. What is that?
It's affidavit for arrest warrant.
All right. And do you recognize it as kind of the template and the ones that are used at the San Antonio Police Department?
Yes,
Would you recognize it as being the affidavit for the arrest warrant of Alfred Flores that you have been talked about previously on your direct examination?
yes.
And I would offer what's been marked as State's Exhibit 197.
Your Honor, on behalf of Alejandro Eleazar, we would object on the grounds that it would open the door to our request for judicial notice that we previously had.
And we don't really have an objection because we actually expect that Mr. Touchy to come, the magistrate will come and testify about the detective line attack. So,
Your Honor, I object to these testimonial objections, the speaking objections. It's 100 times now.
All right, so we had one no objection, and we had one objection related to opening the door on the 202 issue. Is that right?
Yes, Your Honor.
And Your Honor, my means for offering this is optional completeness. Mr. Cifuentes went over this with him, what was missing from it, and almost line by line in his direct examination with Detective Soto earlier. And then Mr. Goss went over it with this witness just a few minutes ago about what's in it and what's not in it.
All right, what's the response to that?
My response is that if they introduce that, then they've opened the door under 202 to the matter that we're asking the court to take judicial notice of. Because what we're arguing is the matter that we want to introduce is relevant about essentially refuting the veracity of this. The document we want to introduce will refute the veracity of this document. So by introducing this hearsay, they're preventing us from introducing evidence to refute it. And they're opening the door to allowing us to refute the evidence.
Your Honor, under the rule of optional completeness, if you admit and introduce and read from nearly this entire document on his cross-examination of Detective Soto, the state, in fairness, should be able to show the rest of the document for the jury to consider the context of it. He was scolding Detective Soto for not including enough information in this affidavit, and the jury should have the opportunity to see what exactly he put in the affidavit then.
So state, would that open the door to that 202 issue?
Has nothing to do with that issue whatsoever.
Your Honor, I think they're mistaken because what our point in cross-examining Soto was that the document 197 states 197 is untruthful. And what they're essentially going to do is make an offensive use of privilege to preclude us from refuting a privileged statement by not allowing us to refute the veracity of this document by the 202 matter.
These speaking objections make it even more relevant and more probative for it to come before the jury, for them to claim that there's information here that are not credible, then the jury ought to be able to see it.
Well, we've already made that point through cross-examination, but if they're going to try to say that it's truthful, we should be allowed to offer extrinsic evidence to show that there's been a determination that it wasn't truthful.
All right, so what I'll do is I'll sustain the objection, and I will make a determination that the introduction of the hearsay document would open up that document related to the 202 issue.
May I ask him questions about it from the same document that they gave him, which is actually the same item?
Yes.
Okay. Mr. Duke, would you agree with me that in the item that's been given to you here, it's not marked, but it's the same affidavit for arrest that I had just identified, right? Or you had just identified a moment ago, right?
Appears to be.
Okay. And when a officer seeks to get an arrest warrant on someone, they have to go through a certain process of presenting the facts to a magistrate. Would you agree?
Yes.
Okay. I mean, for a felony offense that wasn't committed in someone's presence or view, an officer can't just go out and arrest somebody. They have to get a neutral and detached magistrate to review certain facts. Am I right?
Well, no, not if they have reports from a reliable person and it's within a certain amount of time.
There are always exceptions to a warrant requirement, right? But in the circumstances of here, Officer Soto sought a warrant for the arrest of, at least in this case, Alfred Flores, for the offense involved in this case, right?
Right.
Okay, and this is the affidavit he used to present to the judge, who's neutral, detached, right?
Right.
To look for that judge's authority to issue the warrant,
Correct.
right? Okay, and is that what this is?
Yes.
Okay, and you've probably done these yourself hundreds of times. Or not?
I've done quite a few, yes.
Not hundreds?
I would say quite a few. I
Okay.
would say a bunch, but I don't know.
Okay, and particularly on homicide cases, on murder cases or so, would you say that the frequency of times that you would seek to get a warrant is considerably greater than perhaps a property crime?
For me personally,
Yes.
or you?
Yeah, I'll ask for you personally.
I don't know that I don't remember getting a warrant for a property crime.
Well, you were never a detective in any property unit, right?
No.
Okay, and you wouldn't have got a warrant when you were a patrol officer.
No.
That was always something that you needed to get permission from somebody higher up to
That
do.
would be working out of class.
Right, okay. Now, you had described probable cause. Would you agree with me that your definition of probable cause was inaccurate?
No.
Okay. You had described probable cause, the burden of proof of that as being 51%, or more likely than not. Is that what you said?
More likely, yes, more likely than not.
Okay, in fact, that's not the definition of probable cause, is it?
I believe
That's
that.
the definition of probable. So, probable does mean.
It's not the legal standard of probable cause, Your Honor.
All right, you can go ahead and ask.
Okay. That's the definition of preponderance of the evidence. Would you agree?
I would agree, but I also believe for something to more likely have happened than not, if it's equal, then it's 50-50. If it tips the scale to be more likely, you're not going to find 51% in a legal book, but I believe you can interpret it as being more likely than not to have tipped the scale.
Well, probable cause just means a reasonable belief that a crime existed. It's a lesser burden than preponderance of the evidence. Would you agree with me?
Well, my opinion is it's always tipping the scales and more likely to have happened than not. That's my understanding.
That's your understanding.
Right.
Okay? So your understanding is the definition of probable cause is actually at the level of preponderance of the evidence.
I believe them to be the same.
Okay. Okay.
Yeah.
Oh, there's a document there. We'll show that later.
All right, it's about 3:30. Let's go ahead and take a short break. Let's make it as short as we can so we can finish off the day.
All right, retreat.
may be seated.
investigator to, when Mr. LaHood raised an objection to him standing there and eavesdropping, tell Mr. LaHood that he needed to watch his step counselor. And subsequently, there was an argument because,
Yeah, because he doesn't
Nico
tell me to
didn't
watch
watch
my
his
step,
step.
because he's nobody, that's right. He doesn't tell me to watch my step.
right, so
Neither do they.
my concern is that it's improper to send a law enforcement agent out into the hallway to try to listen in on conversations between experts and counsel. And the investigator's response was it was a public hallway, but he knows he was sent there specifically to observe and to listen to our conversation.
And David admitted it.
So we would ask the court to admonish the state that that is improper behavior,
Including the investigator.
and the investigator, that that is improper, that they're not to try to invade the space or the province of those conversations. And ethically, if they see those conversations are occurring, they need to remove themselves and not attempt to stay there and listen to privileged communication.
Your Honor, I will admit that I asked my investigator to watch the fact that they were talking to this witness in the middle of my cross-examination, okay? In the same way that Nico LaHood, every time that we have a witness come back on a break or whatever, asks if the state has talked to them in the interim, for whatever meaning that has. I did not ask him to listen in on their conversations, and I would agree that he should not listen in on their conversations. But it is appropriate to not talk to a witness while they're being directed by the other side. I've lived by that. I know Nico's tried to call us out on that several times, but we didn't violate that rule. And then when they violate the rule, they want to come down on us.
It's not a violation of the rule, because this is an expert witness that is not under the restrictions of the rule. Yes, you cannot do that with a lay witness under the rule. This is an expert witness, and he is free to ask the expert witness if he's had any communications with us, and our witness will tell the truth about whatever was said. But there's nothing fundamentally improper communicating with somebody not under the rule. But what is fundamentally improper is sending somebody out, a law enforcement officer out to eavesdrop on privileged communication between a defense attorney and their expert witnesses. Because Mr. Duke wasn't the only one there. Dr. Martinelli was also talking about trial strategy and some of the other issues that have come up, that we were having that conversation out in the hallway, and it's improper.
And then to attempt a very weak attempt of intimidation. It was just horribly weak. And then when I pushed back on it, and he said it's a free country, it's a free hallway, and he knew what we were talking about. He knows we're talking to him, and he acted like an arrogant person that he is, smiling and trying to antagonize. And so it was just a weak attempt, because he's not very intimidating, so it was very weak, but it was improper in trying to eavesdrop, Judge. And so we're just asking respectfully that you admonish them, including this investigator, so-called investigator, to teach him what he can and can't do when a person has a right to effective assistance of counsel, and we have a right to talk to our expert witnesses.
All right, so
And we would ask, on behalf of Eleazar Alejandro, that this is the umpteenth deliberate, intentional violation of rules of ethics and rulings of the court, and at some point in time, you've touched the boat too many times, and the only remedy should be dismissal with prejudice, mistrial.
okay, so I'll admonish the state and the state's investigator, you are clearly not allowed to listen in to any sort of trial strategy or discussions with any experts and defense counsel. And I'll deny the motion for a mistrial. Anything else?
No, Your Honor. Just to remind the part, is today the day that we have to leave it for?
Yeah, but one of the jurors asked to leave before 4:30,
Okay,
so we'll try to time it between 4 to 4:15.
thank you.
All right, welcome back, members of the jury. State, you can continue.
Thank you, Your Honor. Mr. Duke, during the break, did you meet with the defense attorneys and talk to them about your testimony?
We talked about probable cause.
And, well, do you have a correction about, do you understand what probable cause is now?
I'm sticking to my answer.
Okay. You had began your direct examination with Mr. Goss saying that this was not a thorough and well-executed investigation, right?
Right.
Okay. And then when he'd asked you kind of the details, what I remember you going into was the fact that the fire access door wasn't fingerprinted, there was no DNA taking off of that, and then the measurements that were made inside the window, inside the apartment.
Correct.
And I didn't hear anything else. What in your opinion was so botched and ill-investigated?
As you recall, or maybe you recall, I explained to the jury how important it was to get as much information from eyewitness testimony or eyewitnesses that were there as possible. And there were things that he could have followed up on that he didn't. There were other witnesses he could have followed up with, the 911 caller, that he didn't. So, and we talked about the importance of gathering that information. I don't know if you recall.
Would you agree? You went through all of this investigative work product, didn't you?
Yes.
Did you see that statements were indeed obtained from all the officers that were out there at the scene? They either wrote a report or gave a statement. Is that right?
Yes, but that's different than having a two-way conversation or trying to get more information, because it seemed like there was some things that were unclear.
So what you're talking about are follow-up conversations, because for them to have kind of given a statement, they were in a conversation.
It's not my understanding that the detective is the one that took the statements from the other officers.
Okay.
Is that incorrect?
Well, I mean, is it your understanding from the materials you looked at that those officers that were at the scene all either wrote a report or gave a statement, a typed statement or a written report of their observations, duties, and observations during that time?
Maybe I misunderstood. I was talking about a two-way conversation of gathering information.
Okay. So you think something more than what was done in that case?
Yes.
Right. And then with respect to the 911 callers, did you see in there that the neighbor was talked to?
I saw that she made the 911 call.
Okay, well, you
And
didn't
there
see
was-
the video then where he interviewed her?
I didn't see that video, no.
Okay.
Who interviewed her?
Him or a detective with the investigation? Did you not see that?
Yeah, I didn't see that.
And you know one of the 911 callers was Daisy, the sister-in-law. Right? Did you heard her testify, right?
Well, you talking about way after the fact?
No, she was interviewed that day.
No, I'm talking about the 911 call.
You know, she made a 911 call that day.
I know, that's what I said, way after the fact.
Not way after the fact. This happened that morning when she saw it on the news.
But I mean, it wasn't in a close time span of when the incident occurred.
Okay. Is that all? I mean, did he acquire the video of everything and of the events?
He acquired most of them. There was one that he didn't tag that was lost, or were assumed lost. It's never been presented as evidence. There was 16 bullets fired and recovered, I think, 5. So there's 10 still unaccounted for. The rest, they had a search warrant for the apartment. They didn't take evidence or search the entire apartment. We know from the 911 caller that she was seen with pliers, so she either hid the pliers or she something happened to the pliers. They were not searched for or not found. The batteries were not collected. I mean, there are several things that were not done that should have been done.
talking about now is the investigation onto who cut the fire alarm wires. That's a different investigation. Would you agree?
No, it's what they based the search warrant for this incident on. Right?
They did a search warrant for the fire alarm damage?
I don't think that's what the search warrant, I think the search warrant was for the officer involved shooting.
Okay, so they got a search warrant at what time?
I don't know what time they got it. It was probably, I know that the search started somewhere around 3 o'clock, so. Did I misunderstand the search warrant? Was it not for the officer involved shooting?
It was, but I was asking you about why it was important to investigate who cut the fire alarm wires and doing DNA testing and fingerprinting when the suspect in that case is dead.
Well, I explained that earlier because some people have suggested that she's not the one that did it, that her statement that she did do it couldn't be trusted. So that eliminates the whole reason and justification of why the officers were there and attempting to initially take her in custody.
Mr. Duke, goes on to say that it was a rush to judgment to accuse Melissa of committing that crime because the investigation wasn't done. Is that what you're telling us?
I don't think it was a rush to judgment. I think that this took place in view of a reasonable person, and I think that the officers had the right to make the arrest. It was a felony, and it took place, and it was reported to them by a reliable person. We have the fire department there. I mean, why is that a rush? That's our arrest authority.
Just like it was for Detective Sutter to seek arrest warrants on these.
No, that's different.
16 hours
No,
later.
that's different.
Okay, I'll pass the witness.
All right. You would agree with me in response to the state's question that Melissa did in fact confess to Officer Rojas that she cut the fire at approximately 48, 44 or so when he was talking to her.
Yes.
And also Lieutenant Chris Hesson reintroduced the video of her admitting to cutting the fire, correct?
Correct.
And Melissa Perez gestured, when I cut the wires, using her fingers as the scissors.
Correct.
All right, and you understand under 1403A6 of the Code of Criminal Procedure that when someone confesses to committing a felony, you have probable cause to make an arrest.
Yes.
All right. So any suggestion that she had been improperly accused of committing criminal mischief is simply not true, given the fact that she confessed twice to two different people that were credible and reliable, correct?
Correct.
All right. And whether the search warrant that was issued around 323 was for the officer-involved shooting or for the aggravated assault, there was a search warrant issued for the collection of evidence that did not accuse the officers of murder.
Correct.
All right. And there was questions asked about danger and flight risk. Let's make sure we cover that. You understand that it's SAPD protocol for all officer-involved shootings that the involved officers are photographed with their duty weapons that were used in the shooting, correct?
Correct.
Gunshot residues are taken, correct?
Correct.
And in fact, in this case, one of the CSIs, I believe it was Crane, testified and sponsored photographs that she took of them with weapons, correct?
Correct.
And they were downloaded, right?
Correct.
And you understood that after these photographs were taken and after the body camera footage for the day was uploaded into the Axon servers, that they went to give statements, correct?
Correct.
And that they gave statements somewhere in the range of 6:45 to 8:30 or later that day, correct?
That sounds about right.
And that after each one was interviewed by the officers, but by the detectives in the shooting team, that per protocol, they were reissued new weapons from the armory located within public safety headquarters, correct?
Yeah, I don't know if it was the armory or the ready room, but they were reissued weapons.
And when I say armory in the PSHQ, I'm talking about the ready room.
Right.
So you're correct, I misspoke, but they were reissued weapons from the ready room.
Correct.
And so would you agree that it doesn't make sense to reissue weapons to people who are criminals that might be a danger to the public or might be a flight risk?
Correct.
Do you ever known the San Antonio Police Department to reissue to police officers weapons when they believe that they're criminals and that they believe they're a danger or a flight risk?
No.
All right. So would you say, based upon the fact that they were reissued weapons, we can dispense with any argument that they were a danger or a flight risk?
Yes.
All right. And they were asked questions about whether or not you reviewed videos where you provided transcripts that were made of the body worn cameras.
Yes.
And did you review those transcripts with the body worn cameras?
Yes.
And were those transcripts accurate?
Yes, appeared to be.
And would you agree with me that the transcripts assisted you in looking for information to see whether or not Detective Soto's investigation was complete, fair, and impartial? They assisted you in that regard.
Yes.
And those transcripts were not made by the San Antonio Police Department or by Detective Soto. Would you agree?
Yes.
And you have conducted research in your tenure as the homicide investigator about the probability that someone with schizophrenia would be more likely to commit arson, have you not?
Yes.
What does the learned literature indicate about whether someone who has schizophrenia is more likely to commit arson compared to someone?
I object, it's irrelevant, really.
It's relevant to the issue. They brought up the issue that nobody was in danger.
Not the issue, it depends what the officers knew at the time. They claimed they didn't even know she had schizophrenia in the room.
Well, certainly Officer Rojas did, and if there's any suggestion that Officer Rojas told his chain of command, I think we're entitled to get into that.
If there's evidence that they told the chain of command being Sergeant Flores, I would agree it's admissible.
Well, are they willing to stipulate that Rojas never told anyone that showed up, any of these defendants, and that none of these defendants had constructive knowledge? They're willing to stipulate to that in writing? I'll waive this cross-examination in a heartbeat.
The evidence
If they're willing to stipulate in writing, because we're the ones that are going to be giving up our constitutional right under the Sixth Amendment to confront and cross-examine witnesses. And the only way we can be assured that we're not waiving our Sixth Amendment right is if they stipulate in writing that fact.
I'll overrule the objection.
Do you remember the question I asked you?
Yes.
Is there any evidence that you're aware of that Officer Ramos communicated to Alfred Flores, Eleazar Alejandro, or Nathaniel Villalobos that Melissa Perez had schizophrenia? Rojas.
I don't recall them being told that.
Again, I'm going to ask you, based upon your research, someone with schizophrenia, does the research indicate whether they're more likely to commit arson than someone who's not?
Yes.
All right. And what is the percentage increase?
For females with schizophrenia or other mental illness, it's 37 times more likely than the general public to commit arson.
Hold on to the witness room.
Yes.
What is your basis for knowledge on that statistic? Have you been trained in any of the medical literature involved in that?
Some, yes.
Tell us where you're gathering your facts.
Okay. I have 5 years of behavioral analysis training, also known as criminal profiling. I did residential internship with the FBI's BAU unit. I've also done a residential internship with Florida Department of Law Enforcement. Part of my training, I've had to work some arson cases. Required reading is the DSM, which is the Diagnostic Statistical Manual for people with mental illness or
Can you cite for us, I guess, from what manual or what studies that you've looked at for that figure that you've come up with?
I could if I had my notepad.
Okay, did you bring that with you? Is something you reviewed to help you with your testimony?
I did bring it with me, yes.
I'm sorry?
I did bring it with me, yes.
Okay. I just ask it, according to Gaskin, if he's reviewed anything for his testimony, that it may be made available to the state and the other defendants.
All right.
Do you want me to get it? Yes. Okay.
I guess my question was, do you have like a learned treatise from the people in that science that have documented those statistics?
Do I have a what?
Kind of a learned treatise or writing or publication from a scientific manual or magazine?
Yes,
or
there's.
study?
I have 2 publications.
May I see?
Sure.
Where's the particular information at? In which publication?
Ratios for men, for some reason, women are higher than females. It's 22.6 for men and 38.7% for women.
Okay, what's the figure? It says 20.4 to 73.5. What's that figure mean?
I think it's a variable. It could be as high as 73, with the schizophrenia diagnosis more prevalent among individuals convicted of arson. The whole paper is about the relationship between mental illness, schizophrenia, and arson.
Okay, so just for the record here, the article that you're referring to is Psychiatry, Psychology, and Law. Is that the publication?
I think that's the publication. I don't think that's who did the study. I think these are the people who did the study, and I think they published it.
Okay, and the title of the study is Fire Setting Patterns, Symptoms, and Motivations of Insanity Acquittees Charged with Arson Offenses. Is that
Yes.
right? Okay.
Yes.
All right. I won't object.
Defense?
I just wanted to make sure the state's finished with their board out.
I am.
All right, we would like those individually marked as exhibits and introduced them to the jury as used before the jury.
Treaties under the rules of evidence can be read, it cannot be admitted before the jury.
All right, I'll sustain that.
All right, can you read the portions that you were cross-examined about for each article and tell them what the article was?
Well, there's two studies, one from the National Institute of Health and then the other one that Mr. Limine quoted. But it says there's a strong correlation between fire-setting behavior and mental disorders. There shows a dire need for extensive and detailed collaboration between psychiatric experts, legal practitioners, and fire services. So there's definitely a correlation between mental illness, schizophrenia, and arson. And I'll read. Studies have revealed an association between arson and mental disorders such as substance use disorders, personality disorders, neurotic spectrum disorders, intellectual disability, mood disorders, and schizophrenia. According to Savage, and I'm not sure that I'm pronouncing that correctly, 10% of all convicted arsonists had schizophrenia. We reported 54% of arsonists has a diagnosable mental illness. And mentally ill arsonists set more fires than the non-mentally ill group. Ritchie and Huff, quoting the people who did the study, concluded that 90% of arsonists had a history of mental health issues.
And it looks like you're going to the next article.
Well, yes.
And what's that next article?
It's the one that Mr. Lunan quoted. Psychiatry, Psychology, and Law was the publication, and the name is Fire-Setting Patterns, Symptoms, and Motivations of Insanity Acquittances.
Could you read the relevant passage, paragraphs that address that?
A Swedish study of arson convictions from 1988 to 2000, and it quotes the people who did the study. Anwar, Langstrom, Gunn, and Fazell reported a prevalence of schizophrenia in arson offenders and community controls. And then it goes on to say that the adjusted ratios for men is 22.6 and for women 38.7. And that is compared to the general public.
I want to move on to another issue, the attack on Melissa Perez. You remember when I played for CSI, Jonathan Slinas. Do you remember when I played for CSI, Yvonne Diaz, body-worn camera of Jesus Rojas at approximately, I believe it was 1:51:45, where she's in the bedroom with Santos de la Rosa talking to him, and she's got a hammer in her hand, and then at approximately 1:51:53, she begins rushing out of that bedroom. But before she rushes out of that bedroom, that you can clearly see in Ramos' video that she has a hammer in her hand. Do you remember that?
Yes.
All right. And then within 3 seconds, she presents herself at the window where Nathaniel Villalobos was inside, correct?
Yes.
All right. And so during the time that she's running, do you recall that in that video, people were yelling out, "Hey, watch out, B, watch out, B, she's got a hammer."
Yes.
Right? And so in response to, "Hey, watch out, B, she's got a hammer," he removes himself, correct?
Yes.
And that was similar to how events transpired with Melissa Perez and Jonathan Salinas, correct?
Correct.
And so even though you did not see her swing a hammer in any particular video, you do recall that Maria Salinas said she almost hit you, dude, right?
Right.
And she drew down on Melissa Perez for probably 20 to 30 seconds, you recall that?
Yes.
And then shortly thereafter, we saw Robert Ramos move from right to left behind her. And after he moves to her left, he also draws down on her, correct?
Correct.
So you have two people drawing down on Melissa Perez when Nathaniel Villalobos has his foot on the door, correct?
Correct.
And you also hear Melissa Perez yell at that time, "I don't care, fight me," right?
Correct.
And then later, at 1:57:38, you see, and we played for the jury many times on different videos, I think I finally got it memorized, she used her left hand and used a thumb and finger to indicate that this is how close Melissa Perez came to striking Villalobos in the head, right?
Yes.
And you remember Officer, or actually Detective Alfred saying that at that moment, it's conceivable that Maria Salinas may have seen the swing of the hammer, but the body camera didn't capture it, correct?
Correct.
And also, Vince Gomez, about a minute later, is talking to Ricardo Neri and Andrew Lamb. And while he's talking to them, he shakes his hand. She missed by this much, and the palms are facing each other in front of his face, and they're about 5 to 7 inches apart, correct?
Correct.
And his body camera did not depict the hammer swing, but he stated that he saw that, right?
Correct.
And when you told the state that it was incumbent upon Detective Soto to ask details about why they made that statement, is that what you're referring to in terms of not doing enough of a follow-up investigation?
Yes.
All right. Now, I want to make sure that I also understand another matter that has always troubled me about the affidavit. You would agree that the affidavit that shows the attack on, the video of Jesus Rojas and Jonathan Salinas, and the e-tone shows that this is the sequence of events, and I'm going to name them in order. The first thing you hear is that Officer Rojas yells out as Melissa Perez is running towards the window, "Watch out, watch out, watch out, watch out, hey." Is that correct?
Yes.
And then you see Jonathan Salinas back away from the window, correct?
Yes.
And you see that Melissa Perez, before he backs away from the window, is raising her hammer tomahawk style and bringing it down, correct?
Yes.
And as he ejects himself from the window, you see the hammer come down, and you heard the testimony of all the witnesses. Had he not ejected himself from the window, that the hammer would have struck where his head used to be. You
Yes.
heard that, correct?
Yes.
And you believe that from what you saw.
Yes.
And had he not avoided that strike by having been warned, is it your belief that Melissa Perez would have struck him in the head with
Yes.
a hammer?
Yes.
And would that have been a deadly assault?
Yes.
All right. Then, after she swings the hammer, you see the screen pop out and fall to the ground, correct?
Correct.
And then after the screen pops out as a result of the hammer striking the screen, you see her retract and then strike again, and then move the hammer out the window probably 2/3 of the way, correct?
Yes.
And when she's doing it a second time, she's attempting to strike Officer Salinas.
Yes.
And then as she's doing that, we see Officer Salinas draw his weapon, correct?
Yes.
And as he draws his weapon, he hits his radio and says, "I have one at gunpoint. She's got a hammer." You heard that, right?
Yes.
And then you heard the dispatcher hit the E-tone, correct?
Correct.
Then you saw someone throw the candle at him, correct?
Yes.
And that's the correct sequence of events, right?
Yes.
So to suggest that the E-tone was hit only in response to the candle being thrown and after the candle being thrown, would that be true or untrue?
That's not true.
All right. And so would someone who leaves that out,
So you said that someone had to go by 4:30?
Yeah, we'll go ahead and break then.
all right,
Well,
can I just finish this one question?
you can finish the question and then we'll make the jury
All
happy.
right. And if someone had left out the sequence of events as you said they were, would you agree that's an intentional misrepresentation of what happened?
It's definitely misrepresented. It's probably intentional, but
All right, nothing further, Your Honor.
All right, so members, now, so are you going to pass, or you're still going to continue on?
Can I reserve that for?
Yes, you can do that. You can reserve that. All right. So members of the jury, we're going to go ahead and break for the day. Remember the instructions I've given you, they're going to apply till the end of the trial. Monday, we're going to start up at noon, 12 o'clock p.m. However, make sure that you've eaten beforehand. We're going to go through court till probably about that time, but I'm going to ask that y'all have already gotten lunch. I will not go through till the end of the day. One very significant instruction I got to give you, please be safe. We want all of you to have a good, safe weekend. Get that extra hour of sleep in, and we'll see you Monday at noon.
All right for the jury?